With your permission, I would like to call today's proceedings to order. Never completely comfortable with trying to get through the formal introduction in these university gatherings. Not too sure of the order of precedence. And my recollection of my university colleagues is that they're very busy people. They're always not on time. In the usual course of events, of course, we are guests here, so we'd acknowledge the presence of the Vice-Chancellor. But I was told to advise you that he sends his apologies, as he can't be here today, he's traveling. Next, of course, would be our host for the evening, Professor Denzel Williams, who has advised me to proceed. He's on his way, and he will join us as soon as he can. And that would be the sense. May I acknowledge, I believe I heard his voice, and now I see him, the former Prime Minister of Jamaica, the Most Honorable Bruce Golding. Who's deeply connected, I think, to the discussion we're about to have. We hope later we'll have, of course, the Honorable Marlene Malahu Fort, the Minister of Legal and Constitutional Affairs, and of course our distinguished lecturer this afternoon, the Right Honorable Lord Reid of Alamere. We have a host of persons representing several aspects of our fraternity, legal and administrative fraternity. Mr. Denise Kitson of the General Legal Counsel, Mr. Kevin Powell of the Jamaica Bar Association, and of course the organizer today is Dr. Christopher Malcolm. May I, because I can't, we have this hybrid system. I have no clue who is here and who's not here. But we would expect to be in our community the permanent secretary in the ministry. He has acknowledged that he would come, Mr. Robertson. Mr. Abdul Kader, the Charge Affairs of Nigeria. Mr. Lavalley and Ms. Hutchinson of the U.S. Embassy. Of course, the Honorable Michael Hilton. Has long left any form of representation other than distinguished counsel, but he will, of course, help join us and coordinate the discussions will take place later on. And you will have seen, I hope you have had a program, you'd have seen from that program that we have several participants on that program. In addition to Mr. Hilton, we have Ms. Philippa Davis, we have Mr. Larry Smith from Barbados, we have Mr. Robert Stevenson from the Advocates Association Jamaica, and of course, I'm very proud, I can't tell you how pleased I am that we have representation of the MonaLaw students in that Ms. Ayana Robinson, who will be here today. You might think this is the best part of the proceedings, but I hope you won't say that. So, colleagues, we've called the orders together. I'm begging you to forgive me if I haven't got the entire order of precedence correctly, as I probably should have. But we are bound, as you would understand, by time. You know, there are some constraints that we have to have. And therefore, I'll ask now, is Dr. Malcolm here? I'll ask Dr. Malcolm to stand in for the time being for the principal so we may get our things in order. Dr. Malcolm, please.
Thanks, Chair, and I don't need to because I see the principal walking in.
Well, you know, the good book says you shouldn't lay hands on people so suddenly. But unfortunately, I could understand the circumstances. But sorry for that, colleagues. I'm literally running out of a meeting from 7:30 a.m. this morning. Hasn't finished, and I'm going back to get that going again, but you know how it goes. But so good to be here, so good to see everyone turning out for this very important lecture. Prime Minister Golding, good to see you. Welcome, sir, yeah, and all very distinguished ladies and gentlemen. Dean McCoy, welcome to your home. This is where you do belong. Let me just say how pleased I am to be here this evening, or this afternoon, to really participate in this very important discussion. Because I like the concept, Dr. Malcolm, of reasoning. It says that there's a distinguished lecture on reasoning session about judicial policy construction by apex courts. Now, I don't understand that part, but I do understand reasoning. And I like the concept because reasoning colleagues and friends resonate with us here at our university. You would appreciate that as we continue to build the academy, a big part of what we're doing is what we call thought leadership. Thought leadership is such an important part of our advocacy. And we have within our strategic plan a pillar called alignment. And that pillar called alignment is really looking at how we bring the research and the knowledge that we would have created within our academy to bear on solutions within the broader society. And so alignment is a pillar that we take very seriously at our campus and our university in general. And today's proceedings is really indeed one of those manifestations of how the university is aligning itself to global, regional, and national issues of the day. So we want to really say thank you to Lord Reid for joining us for this very distinguished lecture. And importantly, I want to also thank the members of the judiciary for participating in the reasoning session that is to come later on. Really appreciate that. And we also especially want to recognize and celebrate our student leaders in this regard. And I want to especially acknowledge second-year student, Miss Ayana Robinson, for participating in these very important conversations. So, ladies and gentlemen, I know we have a lot in front of us, and I don't want to be too long, but let me also recognize Senator Scott Motley, who has joined us, and you will be a part of the panel today. We really look forward to the conversation, look forward to the reasoning, but most importantly, when the conversations are done, what we look forward to is the output making a difference in terms of how we do policy and how we actually deal with issues within our society. So thank you very much. Look forward to participating in this lecture. Thank you.
Thank you very much, Principal, and thank you for making the facilities available to us. Colleagues, at this time, we would normally call upon our further host, Professor Shaziza Ali, the Dean of the Faculty. She is not here physically, she's online, and I'm advised that there's a message that she will deliver. I have no clue how the technology works. I'm sending the signals, and hopefully someone will respond, and we'll get Professor Ali's response. If not, I'll have to give you a joke, and that's not going to happen very well. Have you got Dr. Alice? Send an SOS to the technicians. Oh yes, brilliant. We need a sound, please.
Honorable Lord Reid, President of the Judicial Committee of the Privy Council, to deliver today's lecture in the MonaLaw Distinguished Lecture Series. MonaLaw is committed to excellence in legal scholarship, and so we endeavor to encourage thought-provoking discussions as well as research and publications that inform policy making and regional development. In that regard, MonaLaw's Distinguished Lecture Series provides an opportunity for a scholarly discourse on topics that have significant impact on our society. The issues surrounding the role of apex courts in the Caribbean can sometimes become intertwined with political and even emotional concerns. As such, we are pleased to provide an opportunity to facilitate an academic forum where an objective, reasoned approach grounded in sound legal analysis can be pursued on a topic that is of interest to everyone concerned with the administration of justice in our society. My Lord, I am pleased to join the principal of the Mona campus, Professor Denzel Williams, and my colleagues here at MonaLaw to once again welcome you. We are delighted that you are taking the time to share your insight and experience with our audience and look forward to learning from your lecture today. Thank you.
Thank you, Professor Ali. I should confess, colleagues, that Professor Ali is actually attending another conference as we speak on public procurement. In fact, is presenting there, so she's doing double duty at this time. May I now call upon Mrs. Denise Kitson, King's Counsel, the Chair of the General Legal Council, to bring her remarks. Thank you.
Thank you so much, Mr. Attorney. My Lord Reid, our distinguished lecturer, Honorable Prime Minister Golding, Minister Malahoo Fort, and Senator Scott Motley. Of course, you, Mr. Attorney, judges, principal of the University of the West Indies, and eminent faculty members, the discussants, colleagues, both present physically and virtually, including my learned friend, the President of the Bar Association. On behalf of the General Legal Council, the governing body of attorneys in Jamaica, I greet you all well. I must say, my Lord Reid, what a pleasure it is to address you, albeit briefly, without the pressure of appearing before the board on a client's last opportunity to hold or seek to overturn a judgment. Today, we anticipate your presentation greatly, and thank you and all those who made this possible, particularly the class of 1997. I trust, Lord Reid, that one day you will have the opportunity to visit our shores. I must say I'm so disappointed that you couldn't make it this time, but on that occasion, without doubt, you will have an opportunity to interact with Jamaican people, perhaps in a more casual setting, and to visit some of our iconic sites. And so, I wish you well, and I thank you all.
Thank you very much, Chair. I now call upon Mr. Kevin Powell, President of the Jamaica Bar Association, to bring greetings.
Good afternoon, all. It is my honor today to bring greetings on behalf of the Jamaican Bar Association. I think at a time when our society increasingly looks to our courts for definitive answers on a range of issues, governmental action, constitutional interpretation, I think today's topic of discussion is a particularly timely one. There can be no doubt that our courts, especially our apex courts, are particularly important in relation to the policies that they employ that will affect the general landscape of our society and the individual needs of our citizens. I think in that regard, one may raise questions as to whether policy, which is generally implemented by the executive, may create some issues where the judicial branch decides to wade in. there are also, I think, reasonable questions to be asked where our apex court is so far removed from our societal norms. I think in that regard, it is important to recognize that today's lecture will be delivered by the President of the Judicial Committee of the Privy Council, and the Right Honourable Lord Reid, to whom the Jamaican Bar Association extends its welcome and appreciation for his agreeing to do so. I think we look forward to the insights and the perspectives that will be shared today, and we hope that we will embrace the opportunity for meaningful dialogue and an exchange of ideas. Thank you.
Thank you very much, President. I don't think I see the Honourable Malalu fought, in which event may I just then call Mrs. Donna Scott Motley, the opposition spokesperson for justice.
My distinguished colleagues, you'll forgive me if I single out the former Prime Minister of Jamaica, the Honourable Bruce Golding. And I acknowledge Lord Reid. There are far too many people who I know so well in this room to begin to greet them individually. I must say, though, Madam Denise Kitson, that I was absolutely delighted as a member of the Accreditation Committee to see that there was a form being placed in our hands to evaluate this session for accreditation. I want to first of all commend the Faculty of Law for having arranged this discussion. It is most timely, it is indeed invaluable, and it comes at a time when citizens are agitating more and more for answers as to where does justice lie? Who gives justice? But even those calls, they are clear about one thing: we want justice. And I also want to commend Lord Reid, who I have never before had the honor of addressing in any shape or form, to say that I admired his boldness, his courage, and his commitment to transparency and accountability when he wrote to the Gleaner challenging its editorial. I have to say to him that part of what I hope to be enlightened about in this lecture, which I'm looking forward to so much, is the diversity which presently exists at our apex court. Because indeed, hearing matters from different jurisdictions, such as Jamaica, which is highly multicultural, which is very diverse, which has a lot of social problems, and which operates in a particular cultural framework, it would be interesting to understand how our apex court grapples with matters of this sort. I was speaking to a colleague recently, and he was pointing out to me how differently we use the word wicked in Jamaica. So wicked in Jamaica can mean you're a wicked person, but wicked can mean that everything is right with you. It's actually an acclamation. I would also like to hear more about how, in that context, the different views and different objectives are met by balancing the objectives, the policies, which are crafted by the executive, implemented by the legislator, and interpreted by the courts. It is an exciting lecture. I thank you again, Lord Reid, for having agreed to this presentation. And might I say that in my position as shadow for opposition, I intend to take very careful note of all the things that you say, if it pleases you.
Thank you very much, Senator. Colleagues, we're honored today. May I crave a personal indulgence before I go on to acknowledge the presence of Mr. Justice Hugh Small, member of the Constitutional Reform Committee. I'm so sorry. As perhaps a friend and intimate, I tended to overlook him. I'm sorry. Welcome you and thanks for coming. Colleagues, we're honored today to have as our distinguished lecturer, the Right Honorable Lord Reid of Alamere. I trust I'm pronouncing the title correctly. I suspect most common lawyers tend to anglicize all words. I'm terribly sorry, colleagues. The minister is here. Minister, may I ask you to say a few words, please? Thank you.
Thank you so much, Attorney General. Good afternoon, colleagues. Good afternoon to the very distinguished panel. This topic is truly a provocative one. As I considered the content of my remarks, I was reminded that I have unique perspectives on just about anything to do with the law. And these perspectives have been gained over the many years from my performing judicial, legislative, and executive functions and exercising powers accordingly. I have a strong appreciation of and respect for judicial independence as a central component of any democracy. It is crucial to separation of powers, the rule of law, and the protection of human rights. Judicial independence has dual goals: to guarantee procedural fairness in the individual judicial process and to guarantee protection of democracy and its values. I believe it was Johan Steyn, more popularly remembered as Lord Steyn, of the former UK Privy Council, who in his work on the case for a Supreme Court made the point that the judiciary can effectively fulfill its role only if the public has confidence that the courts, even if sometimes wrong, act wholly independently. In the words of Chief Justice Lema of the Supreme Court of Canada in the case of Bean Regand and Canada, it was said that judicial independence is essential for fair and just resolution in independent cases. Beyond that, it is also the lifeblood of constitutionalism in democratic societies. At the same time, ladies and gentlemen, it is indisputable that the foundation of democracy is a legislature elected freely and periodically by the people. Without majority rule, it is said, as reflected in the power of the legislature, there is no democracy. It is also said that legislation and legislatures have a bad name in legal and political philosophy, a name sufficiently disputable to cast doubt on their credentials as respectable sources of law. However, undermining the legislature undermines democracy. Substantive democracy is based on separation of powers. The modern understanding of the separation of power is based on a trinity of branches whose status stems from the Constitution. Each one of the three is limited in its authority and in its power. The legislative branch, the executive branch, and the judicial branch have no authority beyond that granted to them in and by the Constitution. The power of all three stems from the Constitution, whose power, in turn, stems from the people. The importance of the principle of separation of powers is in the very connection between the branches and in the limitations they place on each other. So having said that, I recognize that judicial decisions are commonly characterized along the continuum of activism and self-restraint. I find myself agreeing with those who say that in the absence of definition of these terms, there is chaos and misunderstanding, conducive neither to meaningful debate nor evaluation. For many, these terms have become code words for criticism or praise. So we have A is said to be a good judge because he's activist, or B is a good judge because she exercises self-restraint. Activism and self-restraint, ladies and gentlemen, to my mind, are only relevant when judicial discretion exists. A judge who declares the law exercises neither activism nor self-restraint. A judge who issues an opinion, for example, that the speed limit on the highway is 110 kilometers, as provided in the Road Traffic Act, acts as the mouth of the legislature. His declaration is neither activist nor restrained. He does no more than declare what exists. Activism or self-restraint exists only when the judge makes the law. And I think this is what makes the topic provocative for me. Because in my understanding, there is a policy remit, there is a legislative remit, and there is an interpretive remit. But if you consider further, a judge holds that the speed limit of the highway is such that it contradicts the provisions of the Road Traffic Act. A decision like that cannot be characterized as activist or restrained. It is illegitimate to my mind. Neither activism nor self-restraint justify or permit a decision that violates the law. The concept, therefore, of activism or self-restraint operates only when the judicial ruling is according to law within the zone of reasonableness. Even those who agree with or advocates for judicial activism do not attempt to justify it when the judicial ruling violates the law, more so when that law is the Constitution. Judicial policy constructs by Apex Court. I close my remarks in saying that it is said that the final court is only right because it is final, and on matters where it has pronounced, finally, the legislature has the power to make other laws, if so required, to deal with it. I believe this conversation is taking place at an interesting time, and I truly regret that the other duties of office may not allow me to stay to hear all of the presentations, but I look forward, if they are recorded, to spend some time looking on them. I want to thank you so much for the opportunity to bring remarks and to wish the conveners, MonaLaw, a successful forum. Thank you.
Thank you very much, Minister. Colleagues, we're honored today to have as our distinguished lecturer, the Right Honorable Lord Reid of Alimere. Lord Reid holds a unique position in the common law world. He is not only the President of the Supreme Court of the United Kingdom, but also in that capacity is also the President of our Apex Court, the Judicial Committee of the Privy Council. He has also served on the Hong Kong Court of Final Appeal, which is an interesting experiment that some of my colleagues may wish to look into. Lord Reid was educated at the University of Edinburgh and Oxford, earned a first-class degree at the first university and the Doctor of Philosophy degree at the second. He qualified as a member of the Scottish and English bars, practiced at the Scottish Bar, and served as a judge in Scotland, until 2012 when he was appointed to the Supreme Court. In June 2018, he became the deputy president of that court. And in January 2020, he became the president. If I recall correctly, on the date of his appointment to the presidency, the headline in the Times newspaper read, "Scottish lawyer steps up." In addition to his other responsibilities, Lord Reid is a member of the panel of an ad hoc judges of the European Court of Human Rights and the High Steward of Oxford University. His reputation in the common law world is that he has made a remarkable contribution, perhaps a singular contribution, to the development of the common law. I would say that's interesting because Lord Reid is originally a Scottish lawyer, so we might regard him as one of the many immeasurable contributions Scottish law has made to the English common law. So it's my privilege and my honor, colleagues, today and now, to invite Lord Reid to deliver this lecture. Thank you.
Ladies and gentlemen, I'm most grateful to the Attorney General for that kind introduction and to the Principal and the University for inviting me to give this lecture. I'm delighted to join you and I'm very grateful for the warm welcome that you've given me. How do judges decide cases? I was asked this question a few months ago by a visitor to the court who was surprised when I told him that judges decide cases by applying the law to the facts of the case. Surely, he said, your own personal values must have an impact, particularly in the kinds of hard cases that come before apex courts like the Judicial Committee of the Privy Council. How else could different judges, all equally learned in the law, come to different conclusions on the outcome of a particular case? This lecture is my attempt to answer these questions by giving you an insight into the values inherent in the law itself and the ways in which they influence, constrain, and control judicial decision-making. In doing so, I'm speaking not as a legal philosopher, but as a working judge who is asked almost every day to decide difficult cases which are of considerable public importance in the jurisdictions we serve, including Jamaica. Non-lawyers sometimes think of the law as a set of rules which judges apply in a mechanical way to the facts of the cases that come before them. Some academic lawyers have a tendency to treat the law as a system of abstract propositions applied as a matter of logical analysis. But these views of the law are very different from the reality of the work of judges in the Privy Council. Let me begin by telling you about Imeo, a recent case from the Cayman Islands. It will give you some idea of what a judge like me actually does, and will also illustrate some aspects of how the law operates in practice. The case concerned a multi-billion-pound claim against an international bank, arising out of its involvement in a Ponzi scheme operated by the US financier Bernard Madoff, which collapsed during the financial crash of 2008. The claim was brought after the normal time limit for bringing a claim had expired. That time limit can, however, be extended under Cayman legislation, where the defendant deliberately committed a breach of duty in circumstances where it was unlikely to be discovered for some time. So one of the questions we had to answer was whether that exception applied. That raised some difficult questions, including what was meant in this context by a breach of duty being deliberate. Must the defendant have known that it was committing a breach, or would recklessness be enough? In other words, would it be sufficient that the defendant realized that there was a risk that it was committing a breach and unreasonably took the risk anyway? The answer to that question couldn't be found in the text of the Cayman legislation or in the UK legislation on which it was based. So how did we go about deciding the case? As law students, you probably know that different legal theorists would give different answers to that question. One view, associated with the 20th century American legal realists, is that judges decide cases based primarily on what they think would be fair on the facts in front of them. For example, Jerome Frank has claimed that judges' decisions don't result from the application of a legal rule to the facts of the case, but are the result of the judge's non-verbal hunch, which precedes any analysis and is then translated into a logical verbal account of the facts and the applicable legal rules. In this sense, Frank says judges are creative artists. Legal positivists, like H.L.A. Hart, agree that judges exercise discretion, but only in penumbral cases where general legal rules conflict or are indeterminate in their application. In these cases, their discretion is not unbounded. Rather, judges have a professional obligation to reach their decisions through a process of legal reasoning. They cannot think about the problem purely on its merits, nor can they reach their decisions on non-legal grounds. Another theory is advanced by Ronald Dworkin, who says that judges decide hard cases by trying to find in some coherent set of principles about people's rights and duties the best constructive interpretation of the political structure and legal doctrine of their community. On this view, the principles underlying statutes and precedents always point towards the legally correct answer. That's some of the theory. But what happens in practice? There are cases where my long experience of the law has taught me to hear something that sounds like a wrong note in a piece of music. A recent example from Jamaica concerned the conviction of the appellants Sean Campbell and others for murder. Over the course of the 64-day trial, there was a series of incidents involving the jury. A juror was discharged almost 8 weeks into the trial, reducing the total number of jurors from the usual 12 to 11. Then on the last day of the trial, the judge was informed that one of the jurors, whom I'll call Juror X, had tried to bribe all the other jurors, urging them to acquit the defendants. The trial judge couldn't discharge Juror X at that stage because under the Jamaican Jury Act, a trial for murder cannot continue with fewer than 11 jurors. The judge decided to proceed with his summing up and directed the jury to reach a verdict, reminding them that they had sworn or affirmed that they would reach a verdict in accordance with the evidence they had heard in court. By a majority of 10-1, the jury found the appellants guilty of murder. Juror X was then arrested and was later convicted of attempting to pervert the course of justice. When the case came before the Privy Council, we had considerable sympathy for the dilemma faced by the trial judge on the final day of what had been a long and complex criminal trial. He either had to continue with the 11 remaining jurors, including Juror X, or discharge the jury, meaning that the time and resources spent on the trial up to that date would have been wasted. But that did not mean that he was right to continue the trial. In our view, there should have been no question of allowing Juror X to continue to serve on the jury. Allowing him to continue was an infringement of the appellant's fundamental right to a fair hearing by an independent and impartial court, in accordance with Section 16 of Chapter 3 of the Jamaican Constitution. The direction the judge gave to the jury was not enough to save the situation, particularly as it took no account of the risk that the other members of the jury might have been prejudiced against the defendants as a result of Juror X's actions. Accordingly, the Privy Council concluded that the convictions should be quashed. The case was remitted then to the Jamaican Court of Appeal, who will decide whether or not there should be a retrial. The idea that a juror who had attempted to bribe the others should be permitted to continue to serve as a member of a jury sounded a wrong note as soon as I read the papers in the case. But that doesn't mean that the Privy Council decided the case on the basis of what we thought would be fair on the facts or according to a hunch. Rather, our decision was based on our analysis of the applicable legal rules, which set out a clear requirement for a fair trial and their application to the facts of the case. I heard a wrong note because I've dealt in the past with other cases concerned with juror misconduct and had a strong impression that the judge hadn't dealt with the situation correctly. But I had to go back to the authorities and consider all the arguments with my colleagues before I was sure. What happens then in a case like Primeo, where the effect of the applicable legal rule is not so clear? As I've explained, one of the issues we had to decide concerned the meaning of the word deliberate in the phrase deliberate commission of a breach of duty. Primeo submitted that a reckless breach of duty was sufficient, but the Privy Council rejected that argument. Since words used in legislation are generally intended to be given their ordinary meaning, we considered the ordinary meanings of the words deliberate and reckless in general conversation, as well as the ways in which they've been used in other Cayman legislation. Since the wording of the Cayman legislation was in all material respects identical to the equivalent UK legislation, we also considered case law dealing with the interpretation of that legislation. In addition, we examined the extent to which the Cayman legislation was intended to be a restatement in modern language of the previous common law of concealed fraud, again drawing on the relevant authorities. Our conclusion was that it represented a fresh start, enabling us to give effect to the ordinary meaning of the statutory language as enacted by the Cayman Parliament, without being tied to the past. Another example concerned the powers of the Jamaican Independent Commission of Investigations, known as INDICOM, and its commissioner and staff, and in particular whether they had the power to initiate prosecutions. INDICOM was established by the Independent Commission of Investigations Act 2010 to undertake investigations into actions by members of the Jamaican security forces and other state agents that result in a person's death or injury, or an abuse of their rights. The 2010 Act was passed to address the need identified by the Inter-American Commission on Human Rights in the case of Michael Gale against Jamaica for independent and effective investigation into the actions of the Jamaican security forces, which could lead to independent prosecution. The appeal concerned the fatal shooting of Frederick Mikey Hill by police in 2010. Following an investigation, INDICOM investigators initiated the prosecution of a police officer for Mr. Hill's murder. The Police Federation and others brought an action seeking administrative orders and constitutional redress under Section 25 of the Constitution of Jamaica on the ground that INDICOM had exceeded its powers. In broad terms, they contended that INDICOM only had the power to investigate police misconduct and not to prosecute officers for an offence. The principal question for the Privy Council was whether the Jamaican legislature intended that INDICOM should have a prosecutorial function, in addition to its investigative function. Since the Act which established INDICOM did not confer any express power to prosecute, it was necessary to consider whether such a power arose under the common law. This turned first of all on INDICOM's legal status. The Privy Council concluded that although the 2010 Act did not expressly incorporate INDICOM, it created it as a distinct entity with perpetual succession. INDICOM was therefore in a position analogous to that of a statutory corporation. The relevant case law established that a consequence of this was that in common with other kinds of statutory corporation, Indicom only had the powers conferred on it by the legislation. It was therefore clear that the Act gave Indicom only investigative powers. These examples illustrate some general points. In the first place, even where an area of life is regulated by legislation, the common law remains important. That's partly because legislation usually draws on concepts and principles developed in the common law, or on case law interpreting earlier statutes. In addition, every statutory provision of importance soon accrues a body of case law in which it is interpreted, so that lawyers and the courts consult the cases rather than just the text of the legislation itself in order to understand its effect. In reality, legislation cannot be enough by itself. It depends on the courts to bring it to life and to resolve its inevitable uncertainties, ambiguities, and omissions. A second point is that legal rules are often less clear than non-lawyers tend to imagine. How they are understood and applied by the courts can evolve over time as new problems present themselves and our society changes. In reality, the reasoning of judges in the most difficult cases is often based on understanding the thinking of their predecessors in the context of the problems which they faced, and trying to adapt their ideas to find the best solution for the problems of our own time within the framework of the concepts and principles which the earlier decisions have given us. That involves not only reading the text of earlier judgments, but understanding what the real question was to which the judgment was intended to provide an answer, understanding the historical context, and considering the impact of any relevant social changes which have occurred since then. For example, earlier today, I was hearing a case where the question is whether an injunction should be granted to prevent an employer from dismissing a number of its employees. The law books will tell you that an injunction is not available because the law will not compel an employer to keep on an employee against his will. The leading authorities are 19th century cases concerned with masters and servants, where there was a personal relationship of trust and confidence between the master and the servants whom he chose to employ. Our case is concerned with warehouse operatives employed by a multinational company with over 300,000 employees in the UK alone. Does the rule established by the older cases apply in this situation? We don't answer that question by asking ourselves what we think is a desirable social policy, but by analysing the rationale of the earlier decisions and considering whether that rationale applies in the different set of circumstances before us. In that way, we arrive at a result which fits the circumstances of our own time. Since society is constantly evolving, it follows that the law is in a process of continuous development by judges deciding cases that come before them in the courts. And because we have a system of precedent in which judges are bound by the decisions of higher courts, judgments in the higher courts are not simply decisions on the facts of particular cases, but have to form part of, and often articulate, a coherent explanation of the area of law relevant to the case in question, setting out principles which lower courts are bound to follow. How does this fit with my first contention that judges decide cases in good faith by applying the law to the facts of the cases before them? Some people argue that if that were true, surely there would always be one and only one legally correct answer. Yet the debate before the Privy Council in Primeo, for example, arose partly as a result of what we considered to have been a wrong decision made by the English Court of Appeal in construing the equivalent UK legislation. And there are undoubtedly decisions in the Privy Council which have caused significant shifts in the common law. One example from Jamaica concerned the law of joint enterprise. In 2010, the appellant Ruddock was convicted of the murder of Pete Robinson. Mr. Robinson was a taxi driver, and the prosecution's case was that the murder was committed in the course of a robbery. Mr. Robinson's body was found on a beach. His hands and feet had been tied, and his throat had been cut. A co-defendant, Hudson, pleaded guilty to the murder at the beginning of the trial. However, the investigating police officer's evidence was that Ruddock had given a statement when interviewed under caution to the effect that while he was not the one who had cut Mr. Robinson's throat, he was involved in the robbery and he had tied the deceased's hands and feet. The trial judge directed the jury that Ruddock was guilty of murder if he took part in the robbery and knew that there was a possibility that Hudson might intend to kill Mr. Robinson. This direction derived from an earlier Privy Council decision in a case called Chan Wing Siu, which was binding on the judge. In Ruddock, the Privy Council concluded unanimously that it had itself taken a wrong turn in the Chan Wing Siu case and in the cases which had followed it. It held that a defendant accused of being a secondary party to a crime could only be convicted if they intended to assist or encourage that crime. In other words, a secondary party such as Ruddock would only be guilty of Mr. Robinson's murder if he intended to assist or encourage the primary party, Hudson, to carry out that crime. Knowing that there was a possibility that the crime might be committed was not sufficient. It was simply evidence, although it might be strong evidence, that the secondary party intended to assist or encourage the primary party in committing the crime. It was a question for the jury in every case whether the intention to assist or encourage was proved. This change in approach by the Privy Council was not due to a difference between the personal views or values of the judges who decided Chan Wing Siu on the one hand and those who decided Ruddock on the other. The judges in both cases were engaged in a genuine attempt to identify a coherent set of legal norms from the previous authorities which they could use to resolve the problem before them. As a Canadian judge, Robert Sharp, has said, different judges see legal issues in different ways, and different judges acting in perfect good faith and sharing an eager desire to do justice will disagree. But he added, when I sit down to write my reasons, I find it difficult to describe my approach as being anything other than to do my best to come to the legally correct decision. 3 points emerge from this. The first is that as our legal system is a common law system based on the application of precedent, the primary source of its principles is a historical body of cases decided in the past and collected in the law reports. Each precedent concerns an individual human story which arose at some point in the past and resulted in a legal dispute which came before the courts for decision. In deciding the case, the judge may have articulated a legal principle which he or she understood himself or herself to be applying, or later judges may arrive at a principle by process of induction from a series of judicial decisions in individual cases. The process of development of a common law reflects the nature of its sources. Judges usually find in previous cases the principles which they apply, but as circumstances change and new cases come before the courts, and as the concepts used by judges in the past, such as the concept of what we mean by a family, or what we mean by torture or inhuman treatment, may come to denote other matters from those that judges may have envisaged in their own time, the principles which are inferred from the cases are refined or qualified, and the law develops in a way which is based on, but modifies, the tradition which courts have inherited. In a case which raises a novel or difficult question, the judge's task is to find the legal answer for their own time, and they may therefore need to take account of changes in attitudes and conditions since earlier cases were decided. The second point is that judging can also be affected, consciously or unconsciously, by the social environment in which it takes place inside the court, and by the personalities involved. Some judges are meticulous and conscientious. Some judges are imaginative. Some judges contribute to the creation of an atmosphere which encourages the free and confident expression of views. Some judges are good at working collaboratively with colleagues or assistants. Some judges are anxious to impress others with their cleverness. Some judges are keen to improve their prospects of promotion. Some judges are none of these things. Judges, in other words, are human beings operating in a social setting, and that can affect how they go about judging. My own aim as the President of the UK Supreme Court and the Judicial Committee of the Privy Council has been to create an environment in which everyone is comfortable expressing their own view, in which everyone has time to do their job properly, and in which judges are encouraged to work in a collaborative way, pooling ideas and working together to create the best judgments we can. When I sit on the Privy Council, I'm conscious that we are a group of judges from the UK who do not generally have significant experience of living and working in the jurisdictions we serve. As a result, depending on the nature of the case, we may need to be informed about those attitudes and conditions. In the past, senior judges from a number of other jurisdictions sat on the Privy Council when those countries had it as their highest court of appeal. For example, there was a more or less unbroken presence of a judge from India on the Privy Council from 1912 until 1949, when India established its own Supreme Court. Judges from outside the UK by no means always sat on cases from their own jurisdiction. For example, Sir Edward Zacher, who was at one time the Chief Justice of Jamaica and later the President of the Court of Appeal of the Bahamas, sat on the Privy Council between 1993 and 2004 in a number of cases from the Bahamas, the British Virgin Islands, Barbados, Trinidad and Tobago, and Mauritius, as well as some cases from Jamaica. In my own early years on the court, I sat several times with the President of the Supreme Court of New Zealand. Having the benefit of the opinion of a judge with direct experience of local conditions can only enhance the quality of the Privy Council's decision-making. I've therefore asked the UK government to consider a proposal to invite senior judges from outside the UK to sit with us again on the Privy Council. This isn't currently possible in relation to most of the Privy Council jurisdictions under the legislation which currently governs appointments. The exceptions include judges of the Eastern Caribbean Supreme Court, the High Court of Trinidad and Tobago, and the Supreme Court of Jamaica, who can sit on the Privy Council if they are first appointed as Privy Councillors. At present, none of the judges from these jurisdictions are Privy Councillors, but I'm hopeful that that position may change before long. In the meantime, I and my colleagues pay the greatest attention to the understanding of local conditions explained by the local court of appeal and by the local council who appear before us. That helps explain why it's important that the judges who sit on the Privy Council pay close attention to the decisions of the courts in the proceedings below us when deciding the appeals that come before us. The Privy Council has made it clear that it should not pronounce upon what may be issues of considerable constitutional importance without having the benefit of the opinion of the local Supreme Court or the Court of Appeal upon them. For example, in the Sean Campbell appeal that I discussed earlier, the appellants had advanced another argument, which was that their convictions should be quashed because they were obtained through the admission of evidence in breach of the Charter of Fundamental Rights and Freedoms in the Jamaican Constitution. the appellants invited the board to lay down new principles as to how the Constitution should be interpreted. But their submissions on these points, to the effect that the Charter should be interpreted in accordance with the approach taken to some other constitutional charters around the world, rather than as a Charter of Rights specifically for Jamaica, had not been made before the Court of Appeal in the proceedings in Jamaica. This meant that the Privy Council did not have the benefit of the views of the Jamaican judiciary on these issues. Given the Privy Council's conclusion that the appellant's convictions should be quashed on the ground of juror misconduct, there was no need to decide the question of constitutional interpretation in order to allow the appeal. Accordingly, the Privy Council concluded that consideration of these constitutional issues should be deferred to another occasion on which the board may be assisted by the views of the Jamaican judiciary. This doesn't mean that the Privy Council should always defer to the local courts. As I've explained in Sean Campbell, the Privy Council overturned the Court of Appeal's decision on the issue of juror misconduct. However, our judgments should be informed ones, reached where possible with the benefit of the analysis of the local judiciary. When we sit in the Privy Council, we always display the flag of the jurisdiction from which the appeal before us is being brought on the flagpole in the courtroom. This helps to remind everyone in the court that we are sitting as the highest appellate court of the jurisdiction to which the flag belongs, and we're applying the laws of that jurisdiction. Usually they have a common law system, and their law is similar, if not identical, to that which we apply in the UK. But sometimes those laws and the values that underpin them may differ from those that prevail in the UK. These cases have required us to grapple with complex issues, including the death penalty and gay rights, among others. For example, a recent appeal from Bermuda concerned same-sex marriage, which is lawful in the UK. The issue for the Privy Council was whether the law of Bermuda recognises same-sex marriage. Section 53 of the Bermudian Domestic Partnership Act of 2018 confines marriage to a union between a man and a woman. Other provisions of the Act allow same-sex couples to enter into a domestic partnership with the same legal effects as marriage. The respondents challenged the validity of the section on three grounds. First, they argued that it was passed primarily or mainly for a religious purpose, contrary to the secular nature of the Bermudian Constitution. Secondly, they argued that it hindered their enjoyment of their belief in same-sex marriage as an institution recognised by law. Their argument was that this was contrary to the guarantee of freedom of conscience in the Bermudian Constitution. Thirdly, they contended that Section 53 treated them and others in the same position in a way that amounted to discrimination on the grounds of creed, which is prohibited by the Bermudian Constitution. These arguments succeeded before the Bermudian courts, but the Privy Council allowed the Bermudian government's appeal. The board agreed unanimously that there was no provision in the Constitution which nullified legislation on the ground that it was enacted for a religious purpose. In any event, Section 53 was not passed for religious reasons, but rather as a compromise between different opinions in Bermuda, as well as to fulfill an electoral promise. We also all agreed that we should reject the challenge based on discrimination according to creed. Finally, by a majority of 4-1, we concluded that the Bermudian Constitution did not extend to imposing a positive obligation on Bermuda to make the law comply with the respondents' belief that Bermuda should give legal recognition to same-sex marriage. I want to emphasize that these conclusions were based on our interpretation of Bermudian law, not on policy considerations. They had nothing to do with any of the judges' personal views on same-sex marriage, nor did we seek to impose British attitudes to same-sex marriage on Bermuda. As explained in the judgment, we recognise that marriage is an institution with profound religious, ethical, and cultural significance. that the historical background is one of the stigmatization of gay people, and that the restriction of marriage to opposite sex couples may create among gay people a sense of exclusion and stigma. There's considerable force in the policy argument in favour of same-sex marriage on the ground that it would accommodate diversity within society. But none of this meant that we could read into the Bermudian Constitution a right to the legal recognition of same-sex marriage. We considered that that was a matter for the legislature of Bermuda to be resolved through its democratic process. How then can we honestly assure the public that cases are not simply decided on the basis of judges' personal views of desirable social policy or on the basis of their emotional reactions? As I've explained, we're assisted in this by the surrounding constitutional and institutional framework, which imposes a number of important safeguards. Let me describe three safeguards that our institutional framework imposes. To begin with, the rule of law requires that laws must be administered openly and transparently in the courts. Historically, this has been a challenge for the Privy Council because of the geographical distance between London and many of the Privy Council jurisdictions. Furthermore, until 2009, Privy Council proceedings took place in a fairly inaccessible council chamber at number 9 Downing Street. Things are now very different. The Privy Council sits in Parliament Square, across the road from the Houses of Parliament, in the same building as the UK Supreme Court. The building is open to the public, and we have about 100,000 visitors a year. The Privy Council courtroom is usually busy with school and university students and other visitors, as well as the parties and their lawyers. Privy Council hearings are all live streamed on the court's website and made available on demand afterwards on both the website and the court's YouTube channel. For example, over 55,000 people watched the Sean Campbell hearing live online. This enabled those with an interest in the case in Jamaica and elsewhere, and there was a particularly high number of viewers in New York, to see the arguments being put forward by counsel, the questions being asked by the judges, and generally to get a much better understanding of the proceedings than would have been possible in the pre-internet age. We also live stream the delivery of Privy Council judgments in which there's public interest, when the judge who has written the lead judgment gives a short explanation of the court's decision in ordinary language. We try to do that at a time of day when it can be viewed in a relevant jurisdiction. For example, the Sean Campbell judgment was delivered at 10 in the morning in Jamaica. The Privy Council website provides a brief summary of the factual background and legal issues in every appeal before the court, and the most significant judgments are accompanied by a plain English summary of 2 or 3 pages. We're also planning to make the parties' written arguments available online ahead of the hearing. We hope that these initiatives promote clear and accurate media reporting and make it possible for members of the public to find out more about our work. Of course, I'm conscious of the significant expense involved in travelling to the UK from some of the Privy Council jurisdictions. The Privy Council therefore offers online or hybrid hearings, which can sometimes be the most efficient and proportionate option. This also enables us to hear the case at a time when it can be viewed by the public locally. For example, we had a case from the Cook Islands in the Pacific concerned with the protection of the marine environment. We heard the case online and sat at 7 o'clock in the evening in the UK, which was 9 o'clock in the morning in the Cook Islands. We're also very pleased when we're invited to sit in the Privy Council jurisdictions in person. During my time on the court, we've sat in Mauritius, in the Bahamas, and most recently in the Cayman Islands. The hearings were well attended by members of the public, and we also ran a series of meetings with court visitors, educational events with schools and colleges, and meetings with judges, lawyers, politicians, and other community leaders, as well as taking the opportunity to travel around the islands. The second safeguard I'd like to highlight concerns our obligation to give reasons for our decisions. This has many aspects. In the first place, judges are obliged to reach their decisions by a process of legal reasoning. Only certain kinds of reasons count. Judges are not entitled to decide cases before them for political, moral, economic, or other kinds of reasons. Nor can they simply come down on the side of their gut instinct. What do I mean by legal reasoning? As we've seen in some of the appeals before courts like the Privy Council, the answer can't be found simply by identifying pre-existing statutory or judicial authorities and applying them to the facts of the case. So legal reasoning at this level isn't always concerned only with the legal rules and principles that already apply. It's also about identifying which new legal norms will best match with the fabric and texture of the norms that have come before it. Well, this brings me to another aspect of the obligation to give reasons, which concerns the need for my reasons to be ones that will be recognised and respected by my colleagues on the bench. In the Privy Council, appeals are generally heard by panels of 5 judges, and the process by which judgments are produced is a highly collegiate one, with the judgments often being written by a number of judges working together. After I read the papers before an appeal hearing, I will start to sketch out my preliminary views, at this stage working alone. However, I'm soon required to engage with my colleagues. Before the start of every hearing, the judges gather together to share their preliminary views on the case. Immediately after the hearing, we meet again. At this much longer meeting, each judge gives his or her provisional view on whether to allow or dismiss the appeal, together with a summary of their main reasons. Just as verbal sparring and a blow-by-blow dismantling of a paper are not unheard of in universities, a lively combat of ideas also takes place between the judges at these post-hearing meetings. We learn a lot from these robust encounters, and we have our minds changed by them. If any judge were to incorporate non-legal reasoning into their analysis, this would be challenged very swiftly. Further exchanges of views take place when the judge or judges who have written the lead judgment share a draft version with the other members of the court, generally by email, and they then make their own comments and suggestions. My colleagues' comments invariably improve my drafts, and the final version of the judgment is stronger as a result. And so these internal processes ensure that we work closely together to try to achieve the best judgment possible. Most importantly, our reasons are for the public that we serve. Court judgments need to be able to demonstrate to the litigants and to the public that we've heard and responded to the argument, and to provide them with a reasoned explanation of our decision so that they can understand why we've come down on one side or another. We also need to be able to show in our judgments that we've reached our decision for legal reasons and not for any others. This is particularly critical in judgments given by appellate courts like the Privy Council, when many of the issues we consider matter not only to the parties before us, but also to the wider public. An important difference between the judicial and legislative branches of government is that judges cannot pick and choose the issues on which they wish to pronounce. We can only decide the cases that come before us, and we have to decide those cases, one way or the other. And in the Privy Council, we can only decide appeals from countries that wish to send appeals to us. The larger countries in the Commonwealth, such as India and Australia, long ago established their own highest courts. Some smaller countries, such as Barbados and St. Lucia, have also chosen to end their use of the Privy Council and to send their appeals instead to the Caribbean Court of Justice. Other countries, including some independent republics, such as Mauritius and Trinidad and Tobago, have chosen to continue using the Privy Council. That is entirely a matter for them. We are pleased to provide a service to those who want it, and we also maintain a friendly relationship with those who do not. For my part, I would echo what was said by Lord Neuberger, my predecessor, in 2013, that we believe that the possibility of using the Privy Council represents a valuable contribution to the rule of law, both for particular countries and across the common law world. As the Privy Council continues to evolve, my priority is to ensure that this commitment to justice and the rule of law is felt throughout all the jurisdictions we serve. As judges, it is our vocation to give people a reason to believe that justice is possible. We have a duty to do our best to make justice happen every day, to try to make the world more just for all our citizens. I'm very grateful for the opportunities we have to serve the citizens of Jamaica and the other Privy Council jurisdictions. It is a responsibility that I and my colleagues take very seriously and an enormous privilege. Thank you all for listening to me.
Thank you very much, my Lord. I will now call upon Ms. Munmati Devi Sietaram to move the vote of thanks. Thank you.
Thank you, Dr. McCoy. Good afternoon, everyone. According to St. Ambrose, no duty is more urgent than that of returning thanks. So I am delighted to have been given the pleasant duty of delivering the vote of thanks to our esteemed keynote speaker, the Right Honorable Lord Robert Reid of Alamure, and the President of the Judicial Committee of the Privy Council. Thank you for your enlightening presentation that has stimulated our minds and will no doubt spark meaningful conversations to come later in our program. I especially would like to thank Lord Reid for his valuable insight and perspective on how judges apply the law to facts of cases. The real examples of cases like the Cayman Island case, where the local law and the UK law was not enough to answer the legal questions that arose, and the recent Sean Campbell case, which is a live issue in Jamaica right now before the Privy Council, before the Court of Appeal. It was also enlightening hearing about your individual process of examining the law despite your initial feeling about how a case may appear to you. I also thank you for your noted remarks on the important role of the common law, which has richly developed over the years and is still applicable to some of the modern legal issues faced by litigants. Something I found interesting was the point about how judges may be influenced by socio-economic factors, which are different from the cases and where they emanate from. Commonwealth jurisdictions like the Caribbean may appear very different from what a Privy Council judge may be used to. So undoubtedly, your suggestion to add judges with diverse backgrounds from the Commonwealth to the Privy Council may lend immense assistance in the process of judging cases, and as well as incorporating the benefit of analysis from local judiciary bodies. It was also noteworthy the point that British attitudes is not imposed through cases adjudged by the Privy Council, but rather that the Privy Council has the view that relegating that authority is on the legislation. In closing, your explanation of how the JCPC judges approach a case is illuminating to say. I personally would have never thought that the judges would be, in a sort of way, debate what the legal issue is. And I think that when you read the cases and you see how the reasoning is reflected from the individual judges and how they may reason from a perspective which may be different from another, this may offer confidence to members of the public, especially those jurisdictions like Jamaica, where we always have this active discussion on whether we should stay with the Privy Council or whether we should go with the CCJ. Once again, thank you for your exceptional presentation. I now ask that we raise our hands in a round of applause for Lord Reid of Alimure. I will now hand over to our reasoning moderator, Dr. Malcolm.
Thank you, colleagues. I think we might as just take over my job by inviting Dr. Malcolm here to lead the rest of the proceedings. And I'll invite Dr. Malcolm to come and to summon, in fact, his colleagues, our colleagues, on the panel to discuss this lecture. Thank you very, very much, colleagues. Dr. Malcolm. May I apologize for failing my responsibilities in not acknowledging earlier the presence of His Excellency Marcelo Angel Babi Calvo of the Republic of Argentina. I'm very sorry, colleagues, but I didn't feel confident to stop the lecture to make that announcement. Mr. Malcolm, would you continue, please?
Thanks, Chair, for having taken us so well through the opening part of this program and through the lecture. I'm sure we've all learned a lot from it. I certainly have. I was taking notes. I saw Mike beside me taking a lot of notes as well. And I think we all did. We all learned from it, and we're happy now to proceed into this other aspect of the program, which we're calling the reasoning component, which will in some ways be reflective in some ways of some of the things that Lord Reid may have spoken about, but could also be departing in some other ways as well. And this is where the audience gets more of an opportunity to participate through the questions and answers session. So today we have with us, we have 5 distinguished panelists, including one of our own students here from the Faculty of Law, Ayana Robinson, who happens to have been one of my own past students as well. I taught her last year, right? Yes, I did. And in addition to that, we have, and I'll introduce them individually, but we're proud to see as well that we have a non-lawyer member of the panel, and this is all deliberate. The position is to always have a youth voice in whatever we're doing, and also to ensure wherever possible that we get voices which are not necessarily lawyer voices, because the whole intention, as may have been indicated, is that we're interested as the University of the West Indies Faculty of Law, and certainly as the law schools of the St. Augustine, not St. Augustine, Hugh Wooding and Norman Manley Law Schools, class of 97, in our own outreach initiatives, we are keen on going into the community and trying to get the community as involved as possible in whatever it is that we undertake. So today I will start going from left to right, if I may, with our student, Ayana Robinson. She's only 19 years old, but a brilliant student. She's a Barbadian national and has more academic credentials already established than most will have in a lifetime. And she has many scholarships that she has won in the past, and she is one, as I said, of our brilliant students here in the faculty who wins more awards than we can possibly give out from time to time. But we're happy to have her, and we will be happy to hear her views as she contributes today. Going beyond further to my right, we have Michael Hilton, who is not only well known here in Jamaica, but across the region, across the world, and certainly to the Privy Council, as well as to the Caribbean Court of Justice. He's very well known. He has served here as Solicitor General. He is a preeminent counsel, one of the King's Counsel, and has recently, as in last year, 2023, he was appointed a judge of the Court of Appeal of the Turks and Caicos Islands. He has made significant contributions, including having served as chairman of the General Legal Council as well, and his continuing involvement in the education of our lawyers and our people is legend, and we are happy to have him here with us today. We also have, as one of our panelists, Ms. Philippa Davies, who is, she calls herself these days a legal consultant and policy advocate. She's much more. She's an attorney at law. She has been significantly involved in intellectual property rights and so on. But what we do know a lot about her is that she's never shy about being involved in debating current issues as they come up. And we have heard her voice, and we expect again today to hear her continuing voice, which may vary from other voices, but we're keen for that to happen. We have, to her right, we have Robert Stevens. We typically call him Bobby, and I think that's what he prefers to be called these days. And he is not a lawyer, but one who is a significant contributor to public dialogue, including through his involvement in the Advocates Network. But he has been involved in so many other things. His voice is constantly heard. He has his own unique perspective, and we expect to hear a lot from him today. And finally, to his right, we have Larry Smith, a King's Counsel out of Barbados and a preeminent member as well of the class of '97. And in addition to practicing there and having practiced quite a bit as well before the Caribbean Court of Justice, he's also admitted to practice among other jurisdictions in Jamaica. And in Jamaica, he's a consultant to TWP attorneys at law. Larry will bring his own unique nature and personality as well, including his pink socks, to the table, and we will hear what he has to say today. But again, thank you for sitting by, both those online and those in the audience here physically, as we continue this reasoning session through this dialogue. Now, the way we're going to have this work, of course, is that I will be throwing a few questions out, generally in some instances, and individually to some of the persons as well, which they will take as they deem appropriate. And to be clear, while this session is moderated, the views are organic and are expected to be. And we're hoping that at the end of it, we will hear views which are myriad in many ways and reflective of ideas that we can take on board as we continue the important dialogue, which was in many ways led by Lord Reid in how he approached the issues of how judges decide on what they're about. So in this regard, and without any more time to do, there are a few general questions I wish to throw out, and perhaps I'll start with, in the middle somewhere, perhaps Mike, I think. Middle somewhere. There's a middle, three in the middle and two at the end. So we have to ask this much. And the question is, insofar as one of the things we heard coming out of Lord Reid's lecture a minute ago was the question of a matter coming out of Bermuda, where there was an appeal looking at whether religious rights, for example, could have a significant impact on how constitutional matters are dealt with, and whether you could have a matter being struck down simply on the basis, it appeared, that the legislation that was implemented reflected religious views. Is that a matter which you think in this day and age, bearing in mind, for example, the background of the Hart-Devlin debates, which we know about, going back several decades now, that looked at that question of law and morality and seemed to have settled in a particular way? What is your view at the moment as to how religious views, if at all, should be impactful on how courts decide when they're looking at matters?
Thanks, Chris. Permit me to start, though, by congratulating the faculty, the university, and the class of '97 for organizing this session, and to thank Lord Reid for what I think was an excellent presentation. In relation to your question, I think that religious views, either of the judge or of the society, should play little or no role in deciding legal issues. And I would give the same answer if the question were political views. The judges are, like the rest of us, inevitably influenced by their cultural, social, religious backgrounds. And because of the importance of certainty and consistency in judicial decisions, it seems to me to be very important that judges, and in particular judges of apex courts, should seek to suppress, to not allow those factors to play too great a role, and to hew more closely to what you call black letter law, as opposed to letting those influences determine their results. Because if they don't, you then get a situation where increasingly you get different decisions depending on what judge you go to, which is not a desirable situation to have.
Okay, thanks. Filippo, do you have any views on that from your own perspective as to how that should apply?
Well, thank you. Thank you for the invitation to participate in the reasoning. I would say also that what is before the court is a dispute over the law, and that the court is there to interpret and apply the law, and that we should not reduce our ruling as to whether it is a religious decision or a secular decision. It's a matter that is before the court based on the law that is being disputed. And certainly Parliament makes laws that apply equally to all members of the society, not just those who may claim to be religious or claim to be secular. And it is anticipated that Parliament would make laws that are for the good of all society. And so the court then interprets and applies that law in accordance with the wording of that law and the stated intent of Parliament. So it's not about ticking whether this is a religious or a secular matter, but it is the law that is being contended before the court.
And let me ask Ayana, from your own perspective as a younger panelist here, and including by reference to the discussions you have with your peers, how do they view the question of religion in judging?
Okay, thank you very much for that question, and thanks again for the opportunity. In terms of religion, it is something that has emerged in discussions with my peers, particularly comparing the decisions of the Caribbean Court of Justice and the decisions of the Privy Council. So many of my peers believe that the Caribbean Court of Justice applies a very liberal approach to the interpretation of human rights matters, that they think kind of disregards the religious views that are very dominant in the region. And many of them hold the view that they should play a role in how the courts interpret the decisions. Because coming from the student perspective in law and legal systems, we would have learned that the law is supposed to represent the culture of the society to an extent, so that it can represent justice for the people in the court's role in delivering justice. So many of my peers believe that religion should play an impact in how the courts arrive at their decisions, but at the end of the day, religion should not be the decisive factor, because at the end of the day, as stated before, the court's role is to decide a dispute of law that comes before it in a way that effects justice for the parties of the particular case, in that specific case, and in a way that will be able to effect justice for the entire society. And since religion is something that varies among people, because the Caribbean is a plural society where there are many different religions, religion should not be the decisive factor, but because it is such a dominant factor in the region, it should still be an element that is considered.
Larry, I saw you smiling, and I'll put the question to you in this way. It's two parts, really. One, do you consider religion to be a critical element of Caribbean culture? That's one. And the second bit is, how do you view the role of culture and how it should be treated with by a court, particularly final courts?
Good afternoon, everyone. Thanks for having me back. It's good to be in Jamaica again. I was smiling, Chris, because it was good to hear an accent with which I'm familiar. So that was the reason for the smile. But to my mind, in your first question, just repeat your first question again.
The question is whether or not you consider religion to be a critical part of Caribbean culture. and how you think culture should then affect
I
judgment.
think it is difficult to ask anyone of my age a question like that because not going to church was not an option. You had to go to church. It was just part and parcel of the upbringing. Was I always happy about it? No. But did I have a choice? No. So it has played a role in shaping who I am. At the same time, I tend to agree with what Michael said, which is that I actually feel that it would make for good judging if a person who may have a certain belief, whether you may be, we have a very multicultural society, multi-plural society, Muslim, Hindu, Christian, whatever, usually with one God belief. But my view is that if in determining a matter you can suppress, I would use Mike's word, your personal belief in order to give effect to what you feel is a fair and just determination of the matter, then in my mind, I think that would be a hallmark of being a good judge. Now, to go to your question on culture, I think those two are linked, the whole issue of religion and culture. It is part of our cultural landscape to have religion play a big role. It's interesting. Recently I was here and I heard gospel music being played at an event, and in the middle of the morning, I was pleasantly pleased. But be that as it may, I think we cannot get away from our culture and who we are as a people and what makes us tick. And I think that inevitably you will bring some of that to bear. For example, if I may quickly, in the CCJ case of Smith and Selby, which was a case which dealt with common law spouses, and there was an issue of having to determine what was a spouse within meaning in the Succession Act of Barbados, in the circumstance where the spouse would have been, under normal circumstances, been outed, so to speak, by 9 months because the common law partner was divorced 9 months into the 5 years, so to speak, and the court was able to find a way, looking at the law, to deem the applicant to be the common law spouse. So again, that's a cultural thing in our region, visiting relationships, common law, unions, and so on. That is why we had to bring legislation to deal and address the issue. So I don't think we can get away from that as something that we do, but it cannot, to my mind, be the preeminent thing. The law must always be, at the end of the day, the determination. We must be able to ground the decision that is being made in the law.
And I know the event you referred to as Jamaica Carnival and shipping down the road on the day, but that's another story as to the gospel. But Bobby, getting though to the perspective which is kind of non-lawyer in a sense, of course, are for the benefit of the public that judges serve, right? And if it is that is a significant point coming from the very apex court, the question then is clear, certainly to us, certainly from Lord Reed's perspective, that you can never and should never overlook the views of the society, regardless of what lawyers might think. Now, taking that view with the lawyers kind of being on the outside of your thinking, what do you think the people believe on this matter?
Well, good afternoon, everybody, and it's a pleasure to be here, a non-lawyer. But I just want to say that when you are making laws, you find that the influence of the society and the culture and the religion, etc., will affect the way that the laws are developed. But certainly from the point of view of the court is there to determine the interpretation of those laws in making decisions about certain issues that face the court. So I think that you have to look at it from two perspectives. There will be a lot of influence from the society in terms of what is created as a law for the society. But certainly, it should not have as significant a role as determining the court's positions on things which are really based on the law. They have to consider the situation in the particular jurisdiction, but I don't think that it is as important as dealing with whether it's law or it's against the law or not for the law.
Can I just,
yes.
can I just add to that, to support what Bobby is saying? Bobby mentioned a couple of times, when you're creating law, Parliament, when they're legislating, it's their business to be concerned about what the public wants.
That's right.
And to legislate according to that. I don't think it's the court's role.
Very well. But let me ask you this, though, Mike. Getting back to that Parliament acts, because Parliament, I suspect, acts or should act for good governance for the society. On the question of faith, the question of religion and culture and those other matters, what is the extent to which, flowing from that, you believe that courts should be duly or unduly, as the case may be, influenced by what we call exogenous factors, factors which do not emanate from within the society itself, but appear to be what we consider to be messaging sent from outside? What's the extent to which you believe the courts should get that effectively being brought into their judgments and how they look at matters?
Let me talk about Jamaica's constitution.
Yes.
Our Charter of Rights uses as the standard in determining whether legislation or administrative action is unconstitutional, whether it is demonstrably justified in a free and democratic society. Those are the words. It doesn't say in a Jamaican society. It doesn't say in a society with Jamaica's norms and standards. It says a free and democratic society. I think that that language invites the court to look internationally, invites the court to look at the world at the time the court is deciding it, in determining what does a free and democratic society require, so are involved. And so if that's my starting point, then I think the answer is exogenous considerations are relevant. You ought not to say, I must be guided by what is here to the exclusion of elsewhere. So, and I'm not saying, of course, that you ignore what is here, because in assessing what a free and democratic society should look like, you look at yours, and you look at others.
Let me ask, Philippa, I see you a little quizzical on that one. How do you balance the exogenous and the local when you're considering those sorts of questions as to culture, as to faith, as to whatever it may be? Because those are critical issues that must be decided by a court at one time or another. How do you balance, and who do you have an overriding interest to serve, or what do you have an overriding interest to serve? That which is local, or that which emanates from without?
Well, immediately it's the parties before you and the matter that is to be adjudicated on by the court. But in terms of international messaging, that's a very broad concept. Do you mean discussions in the public or on social media on a matter of international interest? Or do you mean a matter that has been vigorously debated in international fora, negotiated, and is now the subject of a convention, an international instrument that has been ratified by the Jamaican government and brought into domestic law, and then is now part of the body of jurisprudence for consideration by the court? I think we would want to be careful as to what international messaging we would adopt, and certainly the judges are bound by what they can use as their legal precedents for coming to a decision, and that would be Jamaican law, and guided by our Constitution. And our Constitution contains a charter that reflects the classic doctrine of human rights, and so it would be an interpretation applying that classic doctrine and what is established understanding of those classic doctrines on human rights in the Jamaican context.
Yes, Bobby?
Listening to Lord Reid, there are one or two points that came out that I think are very important for us to take note of in Jamaica. Number one was the fact that they consider the social and cultural and economic conditions of the particular jurisdiction. But the fact is, they live stream their hearings. They make them public. They talk about the fact that you know, it's very important for their website to be up to date, and things are online. And in fact, the case that he was referring to in Jamaica, 55,000 people watched worldwide. Now, this is something that I think the courts of Jamaica and the courts of the Caribbean need to follow the example in and begin to make things far more open and far more public. And this point really needs to be taken as a learning point for our Jamaican jurisdiction.
Yep, Larry. Yes, Larry.
Yes, if I may, I see you might have a little wry smile, but the cases of the Caribbean Court of Justice are also live streamed. They have their channels so you can tune in and watch those cases as well. So what the Privy Council, what Lord Reid indicated the Privy Council is doing is not anything that the Caribbean Court of Justice is not doing.
And our full court delivered a judgment on Friday that was live streamed as well.
But there you go.
Yeah, but is it universal?
No.
That's the point.
I'll take your one.
Yeah, but let me ask though, Ayana, before I move on from this point, what is your view though, as to the extent to which local norms, put it that way, how they should be treated? Should they be overridden by what could be considered external norms, or should local norms instead override external norms on this matter?
I definitely think that external norms should not override the local norms because, as Filippo was saying, the role of the court anyway is to determine the matter before it in according to what is the justice for it in the parties of the case. And I don't think necessarily international norms would always give effect to the justice of the case because, as Lord Reid was saying in the lecture, sometimes the cultures overseas may be different from the cultures within, and you don't want to come with a decision that would offend people within the actual society. So I don't think either the cultural norms or the international norms should be decisive in any decision. I think that both must be weighed in accordance with what would lead to the justice of the particular case.
Thanks. There's one thing. I know we're remiss in a sense. We've been speaking here about judicial policy construction, and while we started off without even giving a good understanding of what we think that is, I think it's timely now to get back to that, because the whole idea, if we recall, of this lecture and the reasoning following is really about trying to understand. Lord Reid got at it, and it's for us really to also ventilate a little more. Or what are some of those factors that the public may not readily understand that affect courts in how they decide, and how can the public be a little better informed about how to read into judgments, how to understand where a judgment might veer off from what somebody might consider to be the law as I read it. And I think the critical point there is that as you read it on paper, meaning, for example, a piece of legislation that is out there, that need not be reflective as the judgment says it when in a reasoned judgment that is presented. Now, Larry, on that, your understanding of judicial policy construction in this context is what? For the benefit of the public.
I think before we get to what the judicial policy is, there has to be a judicial philosophy.
Yeah.
A certain kind of viewpoint of the court as to how they will approach matters. And we're dealing with apex court, so certainly what I can glean from the CCJ, both in matters I've appeared in and matters which where they serve other territories of the region, is an approach with the underlying philosophy which addresses the issues of the mores and the values of our society, but more importantly, one that seeks to develop a regional or Caribbean jurisprudence. So, for me, if you look, the judgments, while following the law and the rule of law, are distinctive, for want of a better way of putting it, Caribbean flavor. In terms of the thought process, in terms of the approach to the reasoning of the case, and they follow the law in terms of getting to a determination. So to my mind, that policy is undergirded by a viewpoint that, as a court that is 20 years old, which is young, give an expression to the views and the wills, to the view and the will of a people through the judicial process. Let me put it that way. Completing, I think maybe we were here last time, like I said, the circle of independence. So we are more or less, putting our chest up a bit, but from a Caribbean perspective.
Mike, you know, there's something I need to follow through you on, because Larry has introduced the CCJ and how it functions in this context. I know you have appeared on multiple occasions before the Privy Council. Now, from your observation of how they perform and what you've seen, including by reference to what Lord Reid said earlier.
I thought you were going to say how Lord Reid performs.
So, how do you, not his performance, I'm not going into that. How do you see the Privy Council in their approach, looking closely in their decisions in a manner which you feel comfortable about, including, for example, Lord Reid, when he spoke, indicated that the courts have an obligation to reason for the benefit of the public. One of the things we have noted in recent times is that the judgments have essentially become shorter and shorter. That's one of the things we have noted. Are you satisfied from what you're seeing in that forum that the judgments are doing justice in the way that we heard Lord Reid spoke about it earlier, for the benefit of the public?
Right. So I don't know. I have wondered whether and to what extent there may be policy changes. There have been a number of changes in recent years in the way the Privy Council has dealt with appeals from our region. Some favorable, some I would say concerning. So, for example, things that Lord Reid spoke about, them hearing matters virtually, them sitting at times that facilitate local persons' attendance, as opposed to in the early days of virtual hearings, we'd get about 5 o'clock in the morning to appear. And so those things obviously make the court more accessible. On the other hand, they have increasingly had 3 judges hear appeals. The judgments are shorter. They have, and I think going on right now, is a meeting with the registrar who's discussing with stakeholders some proposed changes to the way matters are dealt with. So you may be aware that one of the proposals is a single judge looking at appeals to determine whether they have merit on a prima facie basis, even if they are as of right. Things like that, which I would say cause concern. Yeah. I certainly got the sense from Lord Reid and from the earlier things I just said that the Privy Council is eager to maintain the relationship. And I don't know how that squares with the other things, but there you go.
One of the things I want to follow up on that with you, Mike, because as I said, what he said, we agreed on what he effectively said. But when you look at the judgments as you have seen them over time, is there any discernible policy position that you can see in terms of their changing attitude to the region and what comes out?
I'm hesitant to say that, to be honest. So if you look at the average Privy Council judgment and the average Supreme Court judgment by the same judges, they're vastly different in terms of legal analysis and so on. But as I say, I'm reluctant to ascribe a policy motive.
And when you say Supreme Court, you mean the UK Supreme Court?
Yeah, UK Supreme Court.
Sure. Yes. All right, so the other thing, Philip, Bobby, really, let me ask you something, because one of the things that seem to be coming up more and more for us, and we've seen it in recent matters as well, is the extent to which the courts are that final authority that protects we like to say that protects the public, the relatively powerless individual, from the might of the state. Yes? And to that extent, there's need for quite a bit of accountability on the part of the courts, on the part of the legislature, the executive, and everybody. But sticking with the court for the moment, what are you satisfied with the level of accountability from your interaction with the public that you see coming through the courts, and in particular from all the levels that we have them?
Well, from the perspective of the Advocates Network, generally speaking, we would like to see a lot more accountability throughout the system, not just in the court, but certainly from the three arms of what you might call governance of the country, we would like to see a lot more openness. We'd like to see a lot more accountability. I mean, you have situations where there are arms of government and departments of government that are spending money at a phenomenal rate that are not accounting for that money. And we think that the way that the court operates, where it makes its judgments public and it operates in a way where you're more transparent, is the direction that I think all arms of the governance of our country need to go.
And getting back, focusing directly on the courts, though, in particular for the minute, do you think, or what would you like to see, if anything, being done by the courts for further openness for the value of the public, if anything at all?
Well, certainly the local courts,
yes.
I think there needs to be a lot more openness. And personally, I think that what is happening now is that it would be much easier if we're in a position where we can refer to a final court of appeal, which is Caribbean, and not one that is based in the UK. So though they are making changes to be more accommodating, as has been suggested by Lord Reid, I still believe that we need to begin to address the situation of adopting the Caribbean Court of Justice as our court. And, let's move in a direction where we truly establish ourselves as independent.
And on that note, Philippa, what are your views on the CCJ? And whether or not it should ever be adopted?
Is that a decision we're to make today, or I just? Well, let me say broadly what I would want to see in the court, that is to be Jamaica's final court of appeal, the apex court. It's not about geographic location or the hue of the judge's skin, or whether the judge has historical or nationality ties with the parties before them. I think those are superficial characterizations that can either detract or distract from a substantive discussion. I think that it's the judges or the court shows that it will adjudicate on the law before them and concern themselves with the law before them and be bound by the principles that are to be applied of the law before them, not to bring in extraneous matters or international messaging that is not in the domestic law. I think that is an important framework that we would want to use to examine whichever court that we would be submitting to as our apex court.
And Ayana, on that same question, from you and from your peers, what is the general consensus, you think, from what you have derived as to the CCJ?
Okay, I would like to preface my response with the fact that whether Jamaica accedes to the jurisdiction of the Caribbean Court of Justice is ultimately a decision for the Parliament and people of Jamaica. In terms of the student perspective, I think that there are divergent perspectives on the matter. On the one hand, and the opinion to which I subscribe is something that Lord Reid was talking about in his lecture, that the Judicial Committee is divorced from the culture of the region. And in response to that, they have adopted this position of deference when they are interpreting matters in the Caribbean, particularly constitutional matters, because they do not want to make any decision which could offend people. And while I respect what Lord Reid is saying, that he's trying to, tread on the side of caution, I believe that sometimes it could undermine Caribbean constitutions, which are supposed to be the supreme source of law. So this is a position that they have adopted for a long time. And even Lord Hoffman said when he visited Trinidad and Tobago in 2003, that he believes that at times this has led the Privy Council to make the wrong decision because they're not able to understand the issue. And because they don't want to offend anyone, they might take too far of a step back. So in constitutional law, we would have looked at the case of Hines and the Queen, which is a case from the 1970s. And there, the board would have stated that, when we're dealing with these kinds of matters, we're not going to say that parliamentary legislation is unconstitutional unless we can prove bad faith on the part of Parliament, which is a very high threshold. And while they might not be applying the precedent, up to last year in another case called Jamaica Bar Association and the Attorney General, when the board was looking at applying anti-money laundering controls to lawyers in Jamaica, they still cited Hines, and they still considered that they had to allow Parliament this margin of appreciation. So from my perspective, and from many students' perspectives, it would be in the best interest of Jamaica to go to the Caribbean Court of Justice, which would have been trained in Caribbean constitutional law to uphold our Constitution. However, on the other hand, some students do believe that the Caribbean Court of Justice may be too close for comfort, so to speak colloquially, and that there may be this compromise of judicial independence, as the minister was saying earlier, that the court has to be independent. And some people believe that, you know, we're here, I'm Barbadian, I'm in Jamaica, they have lawyers all across the Caribbean who know each other, and that might undermine the independence of the court because people know one another so closely, or might know the culture so closely, whereas the Privy Council, which is outside, might actually be this impartial person. And as Mrs. Kitson, I believe it was, she was saying earlier, for many Jamaicans, the appeal to the Privy Council is their last opportunity to have a decision decided in their favor. So it is a complicated matter where there are a lot of divergent perspectives. I really, sir, at this time, I cannot give you this one student perspective. I don't think there is one.
But Larry, I know you're
Mike was going to say something.
Sorry.
You want to speak, Mike? Go ahead.
Yeah, Mike.
On the question of acceding to the CCJ's appellate jurisdiction, distance is not what creates judicial independence and judicial integrity. It is the way judges are appointed, it is the security of tenure that they have, and it is whether there are any avenues for interference. So I agree with what Philippa said about the characteristics that you want of a final appellate court. But, the High Court of Indonesia may have those characteristics, but we will not want them as our final court, I don't think. We want a court that we have a say in the appointment, we, the people of our region, have a say in the appointment of the judges, in the creation of the rules under which they operate, in the way the court is run. And it's just not our court.
Okay, Larry, I know you're a consummate CCJ man, to put it that way. But one of the things that appeals to me about the idea of going to the Privy Council, or one of the arguments, whether or not we have seen it in practice or not, is another story. But the big argument is that we're seeking to create a Caribbean jurisprudence. And to the extent that we're saying the CCJ is to be preferred, if we're following that argument, it is on the basis that we can see developing through it something which is much more Caribbean and much more reflective of who we are. Yes? That is an appealing matter for me. Now, based on your own reflection of CCJ judgments and what you have seen, and I'm going to make a comment and before I preface that. For me, I'll add to that my favorite Caribbean judgment of all times was Mitchell and Cowie. Take up your chattel house, move it because you don't own the land, and even though you've put it on the land, it is not part of the land as traditional land law would say. That is clear Caribbean jurisprudence developed to reflect our history of slavery and the other things coming out of it. Now, from your own reading of the Caribbean judgments and as you see them emerging through the CCJ, have you seen a defined Caribbean jurisprudence emerging one, or have you instead seen a group of judges sitting in the Caribbean, being Caribbean people primarily, who are simply putting forward judgments which are reflective of much more of an international setting rather than a setting which can be deliberately considered to be Caribbean in nature? What have you observed from your own reading?
Firstly, just before the comment made by Ms. Robinson, and this view somehow that because our judges are nearby, Trinidad is 35 minutes away from Barbados, a little bit more from Jamaica and so on, somehow that the close proximity creates a problem. I think Mike said it well, where distance doesn't impact your integrity one way or another. You either have integrity or you don't. And Mike, who serves on the Judicial Legal Service Commission of the CCJ, Regional Legal and Judicial Service Commission, can perhaps speak better to this than I can. But the code of conduct for the judges of the CCJ is available for all to see. If the issues of complaining for judges is there for all to see, you can, if you have a complaint, you can address that. And so the issue of transparency of the court is clear and second to none. And I read a lecture that Sir Dennis Byron gave some years ago in Jamaica. It was an interesting argument he made. He said, in small societies, the judges are well known by the people. Everyone knows them, how they conduct themselves both on and off the bench. The judge is almost literally under the microscope of public attention. It is generally considered that courts gain confidence by being transparent. This reasoning would suggest that confidence should be generated from knowledge. I would have thought that it is easier to trust those who you can see and observe than those who you do not know. Could not have said it any better than Sir Dennis. I think it's very clear to my mind. Now, to the question that you were asking me, what I've observed, I think perhaps the major thing, what we are seeing at the CCJ is what I call the issue of the savings law clause. That has been a big issue. The Nerve case, then there was the McEwen case, then there's Bizram, and so on. But then the Privy Council and Boyce and Joseph and so on, and they just came now, but a definitive position in J. Chandler. And I think what struck me, because my colleague in Chambers, who teaches constitutional law at KFL, he has a different view from me on certain things, and so we were discussing the case, and I read the J. Chandler case, and once you go through it, you will see that in Boyce and Joseph, which is out of Barbados, the court came down on a 5-4 position that the savings law would trump the right that was being infringed. It was a 5-4 decision. They have later moved away. When they say moved away, the Privy Council now has gone and they've doubled down, and that's their position is as expressed in Boyce and Joseph. The Caribbean Court of Justice's position is a position which, to my mind, if you're talking about the judicial policy of an apex court, what you can see is the court seeking to give effect to what I think Sir Dennis said in Nerve to be the aspirations of our people. So that it cannot be for us where the savings law was to serve a particular purpose, to make sure that things don't fall apart on independence. In the case of Jamaica, you are 60 years on. Barbados, we are 55, 56 years on, and so on and so forth. Guyana, 60 years. Trinidad, we are some way down the road in this incomplete journey. And so, to my mind, to hold to a position which will say that the savings law clause will get primacy may be one which emanates from a thinking of parliamentary sovereignty. One which seeks to go with the constitutional supremacy, which is our position here in the region, will find that you will get a decision where the CCJ has gone with the savings law clause. So whereas now in Nerve, you had a dissenting judgment, though coming to the same conclusion of Mr. Justice Anderson and Mr. Justice Rajloff Lee, you kind of in Bizram, unanimous decision of the court. So what you have seen now is even those judges who may have had reservations with time have been able to have seemingly a position where they can all agree on the approach as it relates to the issue of the savings law clause in many of our constitutions. And you can see now the forward thinking. Belize had a 5-year moratorium on their savings law. Grenada didn't put it in at all, having recognized some of the challenges. So that, if you look at those cases, you would see a distinct approach of the Caribbean Court to give effect to us as a people within the confines of the law. They didn't go anywhere, they weren't wild about it, but very reasoned a very reasoned approach in determining how we should deal with the Savings Law Clause, and an approach which gives the fundamental rights and freedom sections meat, and because bear in mind that in J. Chandler, once you read J. Chandler, you will find that the judgment of the Privy Council said that both positions are tenable. So my question is, if you have a position that is tenable, which will eschew the right, and one which will give effect to the right, why are you siding with one which will do away with the right, as opposed to one that will give effect to the right? And if you look at the preamble of many of our constitutions, and I'm a little bit more familiar, obviously, with the Barbadian position, but it says that in our preamble, it says something to the effect that whereby, over time, we have given an expression to the expansion of rights. Then how do you come to a position which seeks to limit those rights? So that is one area in which, to answer your question, I see a clear policy approach of the court in constructing its decisions, and the philosophy undergirding that is one which is to recognize as a former colonized people and someone who is seeking now to forge their way, that we will interpret those laws where it is permissible in a way which gives effect to those goals and aspirations of our peoples. And to my mind, when Lord Reed said, look, we don't have knowledge of your local conditions and so on. So when the issue was raised in the I say Vibes Cartel, but when Sean Campbell, yes, when the issue was raised in the case, their position was it wasn't addressed before the local courts, so we cannot offer an opinion on it. What happens and has happened at the CCJ if something was raised, but the court deems it important. The court has said, in my understanding, look, I want to hear both sides on the argument. We are prepared to hear the matter. It happened in the Frank Gibson case that I did, where the court, something was raised. The court said, we will hear you. So here you have a court now that is saying, I'm not going to wait until it comes back again, because if there's a constitutional conundrum, then it has to wait until whenever somebody raises it, the court in Jamaica, or the court in St. Vincent and the Grenadines, or in the court in Antigua and Barbuda, as the case might be, addresses, or the OECS Court of Appeal addresses the issue before they are prepared to say, okay, we'll defer to your local judges and how they have assessed the issue. So in essence, then, even though they may opine on the matter at a later stage, having had that expression from our local courts, it is really the expression that is given by the local judges that they are holding on to. And those are local judges sitting at the Caribbean Court of Justice. So to me, it is mind-boggling, to say the least, why it is still an issue. And one thing, by the way, which I noticed it wasn't addressed by Lord Reed, while he acknowledged making the hearings accessible and reducing, allowing people to appear online and so on. I noticed absent from the lecture really is the issue of the costs associated with actually having your matter heard at the Privy Council. YouTube is fine, great, with fantastic stuff, but we have that too. Online hearings, that is fine, we have that too. But can I appeal as a poor person? No, we have that though. And that is the issue. Access to justice is the fundamental issue, particularly for those of our citizens who find themselves on the margins of our society. That is the real issue. And so we have a court with a policy that will say, look, these are some important legal issues here, and we will give you leave to appeal as a poor person. The Frank Gibson case, and I say it because I did it, but not only for that, but if that was the matter, for which the Privy Council was the final court. I'm sorry, but the decision of the Court of Appeal of Barbados was likely to have been the final decision in that matter. My client had no money. To say he was impecunious was generous. So that he was able to appeal, and that case now has been an important, it's been cited in nine other Caribbean jurisdictions. It's taught at the law school here. Again, not because there are other cases out of Guyana and Belize, particularly dealing with indigenous peoples and so on. So let us look that there's a policy of the court of giving the widest access possible to the majority of the people who are able. So what the people of Jamaica have to decide is not for me. What the people of Jamaica will have ultimately to decide is, do we want a system where, and it's in both in Sir Dennis Byron's lecture as well as one given by the current president in 2022 here in Jamaica on the 60th anniversary of the establishment of the Court of Appeal of Jamaica. What you will have to determine is it sufficient to have 260 cases determined by your Court of Appeal and 4 at the Privy Council in the same year? Is that good enough for you? Is that good enough for your people? Is that good enough for your society, for the development, not just of your society, but for the development of your jurisprudence?
All right, thanks. Philippa, I know you have some comments that you wish to make.
Yeah, I just want to ask Council Larry, just based on some of the reference he was making from the former president and current president of the CCJ when he spoke about the aspiration of the people. But when I would ask, where is the best and fit forum for the ventilation and the debate of those aspirations? Is it not through the people's representative with their members of parliament and in parliament? It is not the place of the court to decide and debate on those aspirations. And secondly, speaking about expanding of rights, judges don't have any authority to expand the rights. That is a question about the international messaging and what messaging is being taken by the court if it's influencing a decision. The rights are what are set in our constitution and our charter, and that is what the judges are to rule on. They have no authority to expand rights in a matter being brought before them. And I would want to ask, at that same 2022 event when the president, Honorable Adrian Saunders, how would you take his comment where he says that the CCJ is an executing agency for UN donor funds, and where he also had said that judgments of the Court of Appeal should be appealed to the apex court so that the court can interstitially and in partnership with the legislature close the gaps between law and society. Judges do not have that role to close the gaps. They are to argue on the law before them. But how would you take his declaration that the CCJ is an executing agency for UN donor funds? Is that not outside influence and a role beyond a court?
Thanks, Philippa. I'll start first with the issue of the aspirations. I believe my understanding when the court spoke about aspirations, that those aspirations are expressed quite eloquently. And let me speak about Barbados, and I suppose you can look at any of our regional constitutions in the preamble of the Constitution. So that when the court speaks about giving expression to the aspirations, it is the expression to the aspirations which the people themselves have said, Parliament, in its preamble to the Constitution. Therein you find the aspirations. So when the court, for example, you see nothing in the Constitution that speaks about, well, the Constitution of Barbados, when last I read it, that says anything about the rule of law. You have the protection of the law. But in the preamble to the Constitution, it speaks about whereby the people are given to the rule of law. So therefore, when the court then makes the determination on, well, the rule of law is getting its strength, so to speak, from the preamble and the aspirations therein set out. So that is what I mean, my understanding of those aspirations. It is found in a document that you can actually refer to. Now, you then spoke about interpreting the law. You said about the court expanding rights. So, for example, Section 11, well, we're here in Jamaica, but I think Jamaica having this charter, the right to life, right to life, liberty, and protection, right. So, security of the person. I have argued, one judge saw it my way, one didn't, that the security of the person right deals with issues of, let's say, the psychological aspect of the human being. Because you have a right to life, fine. You have a right to liberty, that's physical. So what is security of the person? What does that mean? So when we speak about expansion, it is not expansion as we are adding something to the right. We are saying an expansion in our understanding of what it could mean and what it ought to be in a society that is evolving. So as our society evolves, we're saying, okay, if a man or woman has a criminal charge hanging over their head for 5, 6, 7 years, there must be some kind of psychological overlay which attends that individual. We live in small societies. We know what it is when you have a murder charge or you have a charge for robbery. You know, we say, don't mind he's thief. That's what we say. You go to court and you can be found not guilty. He had a good lawyer, but we know he's a thief. So where is his right to the security of person to be found? So when they say the expansion of rights, we're not adding anything that is not there. What we are doing is giving a purposive interpretation.
Larry, I cut you there because that's good lawyering on your part, and we hear it. Exceptional lawyering, actually. There's an element as to whether expansion is to be interpreted as you have said it, or whether you can, by reference to the judgments or anywhere else, see that expansion goes beyond that interpretation as you've given it. We're not going to ventilate and complete that here. But there was one other question, though, I heard Philippa ask, which I think is perhaps more germane, is if a court says we're an executing agency for the funds of an international organization, the question is whether that impinges in any way at all, or constrains in any way at all, or determines in any way at all how the court functions and whether the court in any way can be considered as treating itself as being beholden in any way. And I'm not suggesting that it is. The question is whether the very expression in that way is itself problematic. I suspect that's what I heard Philip ask.
Yes, and I think I have it. Page 12 or 15 of the lecture given by President Saunders. Thirdly, the international community has identified the CCJ as an appropriate executing agency for donor-funded projects designed for justice improvement throughout the region. So, for example, over the last 8 years, the CCJ was the executing agency for the Canadian-funded Judicial Reform and Institutional Strengthening Project, JURIS Project. The JURIS Project has engaged in several initiatives, including the establishment of Sexual Offences Model Court in Antigua and Barbuda, the development of model guidings for gender-sensitive adjudication in collaboration with CAJO and UN Women, and the establishment of the soon-to-be-launched Caribbean Judicial Information System, CJIS. The CJIS will serve as an information hub for judiciaries across the region and will enable effective storage and access internally and externally to information such as judgments, policies, procedures, project information, rules, guidelines, and the like. So when you read the lecture given by President Saunders talking about execution agency, it has nothing to do with when the court is dispensing its justice. Exactly. Nothing at all to do with the court delivering any judgment or hearing any matter. These are tangential matters which may aid in the society and how we may address certain things, certain issues of justice, but it does not touch and concern, indeed impinge in any way whatsoever, the role of the court as an adjudicating body for those who have it either in its original jurisdiction, which is all the Caribbean territories, or who have the court in its appellate jurisdiction, of which we are 5. So once you put it in context, and the statement of the president, you recognize it has nothing nothing to do with the court as an adjudicating body. And I trust that answers the query.
I think, Bobby, before you, Mike, Bobby has a point on that.
I just wanted to say that, look, what is important is, do we have confidence in the judgments coming out of the CCJ? CCJ has been around for what, 15, 20 years now. And it appears to me, just as a member of the public, that 90% of the decisions of the CCJ are accepted throughout the Caribbean as being fair. So really and truly, I think there was a former Prime Minister of Jamaica who said, look, in order to really find out what this court is all about, let's give it 10 years. And, you know, I think that we have gone way beyond the 10 years. We seem to feel that the court is very fair. As far as I'm concerned, that's it.
All right, Mike, I'll give you some final thoughts before we ask. What I'm going to do after you have commented here is to ask each of you to, in a very short way, tell me 3 things, or not as many as 3, 2 perhaps, that you expect to see in every final court as they seek to serve the public. 2 things. But Mike, before you get to that.
The comment I wanted to make, just to follow up on Philippa's point about courts expanding rights. Apex courts do expand rights, ultimately. They do. They do in the sense that Minister Malou made an observation about separation of powers, binding courts as well, and she's right. Courts ought not to trespass upon the roles of the executive and the legislature. But the Constitution is above all of them. And for right or wrong, for better or worse, the Constitution gives the court the function of interpreting it and of applying it. And so the courts determine whether, what does this right mean? What is the scope of this right? And if we say as we do, that our constitutions are living, breathing things, the scope and the meaning of the right changes. Our understanding of society change. And it's the court's function to change it.
All right. With a lot more that could be said, I'm going to now ask Ayana. What are 2 things that you would like to see or look for in every final court in terms of messaging that you hope to see coming out of every court when they decide matters for the public's benefit?
So I think that an apex court should always try and stick to what is the true function of a court. So I see the functions of the court on 2 sides, that is a court of law on one side and a court of justice on the other side. So as a court of law, I think that when the court delivers its decisions and in its messaging, one of its primary objectives should be to deliver and maintain legal certainty so that citizens have a body of law that they know this is the law and this is what I have to follow to stay in conformity within the law. And I also think so that legal practitioners know that there's this body of law on which they can advise their clients. As terms of a court of justice, I think that the court has to always remember, even though they have to bear the policy considerations to make sure that they deliver a decision which will promote justice in the wider society, that they don't forget that they have to deliver this decision in the particular case that would affect the justice of that particular case, rather than just trying to deliver a decision that comports with the established precedent or legal rule that they have before them. And striking a balance between that and the policy considerations that must be considered to make sure that the decision does not lead to legal uncertainty.
Larry, in 30 seconds, what are your 2 things that you expect of
Again, I will borrow then. I can do no better, I suppose, than borrow from President Saunders. He said, the role of an apex court is not just to correct errors made in a particular case. An apex court is a reflective body whose decisions go beyond the litigants in the specific case. Those decisions are aimed at the judicial system as a whole. Apex courts engage in system-wide correction. For the rule of law to operate in the dynamic manner it should, it is vital that a final court should be accessible to all who have hard cases. So 2 things I would like to see, which is what I see at the CCJ, is that there's access to the court. You can actually get there in a meaningful way. And of course, a lot of it is now about human rights. So therefore, that when the appropriate matters come before the court, that the decisions give effect to, let me not say expansion of rights, but rather for the most liberal or purposive approach of those rights that are available to the citizens, so that, justice ultimately is available to the majority of us.
Okay, I won't get into whether or not there are rights which are contestable and those which are fundamental now. But Bobby, what are two things you expect of any final court, certainly, and any court at all, as a member
Any
of the
final court, number
Yes.
one is accessibility.
Yes.
And it should be accessible to all the people.
Yes.
And number two is that it must be able to be reflecting the social norms and conditions of the people. As Lord Reed stated today, they are now trying to move towards having people from outside the UK sitting on the Privy Council. We already have a situation where we have a court in the Caribbean that has Caribbean people. We don't need to do that. Let's go with the CCJ.
Filippo, what are two things you expect to see coming out of the judgments of final courts?
One is definitely to ensure a fair legal process and that there's a higher standard of judgment by judges judging impartially in accordance with the law. But the second is to avoid judicial activism. And that is engaging in judicial legislation where judges create new laws or modify existing ones through their decisions.
Mike, I'm not sure you agree with judicial conservatism, but what are two things you expect?
And there's a lot in between activism and a big. So a number of the things that others have said, I would have said, but let me add one. Confidence.
Yes.
Confidence of the people and the public that they serve. It's really important that we have a final court in particular that the people can be confident in serving their needs. And part of that, perhaps I'll then add independence of thought and function and so on, which then gives the confidence.
Okay, fine. So we're going to take some questions from the floor. I know time is there, but I know there are a couple of questions, and I know the time you're pointing to me, Hugh. I see your hand, but we have a few questions that we will want to take in any event, notwithstanding. But let me just say before we even go there, in the interest of time, that we're very thankful to the panel for making themselves available and for delving even longer into what we got into than we intended. But it was organic, as I said it would have been, and I didn't want to cut too many persons off as they tried to get on with the matters. But quickly, for any questions that are there, and I'm seeing Dr. West over here. There is a mic that is to be passed on to you. Quickly. We're recording it, so that's why.
Testing. Yes. Thank you. When I hear the word policy, I immediately think of politician. And it means that the politician is bringing something which the people will evaluate, accept, or reject. So when I see judicial policy construction, why shouldn't I think that anybody who is doing that, any judge who is engaged in that, should also be subject to the ballot? Because as is, judges are presently protected. So wouldn't that be totalitarianism as opposed to the democratic process?
Is there any person in particular you want to address it, or you want just a general commentary on it?
Oh, just a general commentary, anybody?
I suppose the question is, and I'll ask Mike if you want to take that on quickly.
Yeah, I mean, I would agree that judges ought not to make policy.
Yes.
That's not their role, and they're not elected representatives. That's a role for politicians, as you see. You can get into an argument as to what crosses the line.
Yes.
Because in interpreting what does this word mean and this right mean, inevitably one's understanding and background and the time that you're in influences it. So, I agree with you in principle.
I suppose, yes. And just the short answer here, Dr. West, is that invariably subjectivism comes in at one level or another. However objective a court may be, you do not go to a bench and simply become somebody other than who you are. And by reference to the society in which you were brought up and the influences that got you to who you have become. So to that extent, we see. The question, though, bigger question I heard you ask, is whether they too should be subject to accountability. And the short answer is yes. And I think it is where institutions like this and otherwise, and I think we do some of it already through dialogue, should do a lot more perhaps in interrogating judgments and having public discourse about critical judgments as and when they arise. And I don't think there's anybody on the panel, not even Larry, who would say there's not a need for the public to, in an appropriate way, interrogate judgments as they happen.
To answer Dr. West on policy, I have a slightly different view. A court can have a policy where it is, we have to find a solution to the problem that exists, not to make up anything. So those are the lawyers here, Donahue and Stevenson, are known before to the common law. Hadley, Byrne, and Heller, again, they had to find a solution to a problem. Okay? So that is a policy. Common law is the common law, or the law which we receive from England and so on. It's a policy-made law. You know, there's a saying in tort which is that no wrong can go without a remedy. So if we do not know a remedy, but we can see a wrong, we have to fashion one. Because otherwise it would mean that the policy is, if the law doesn't say, Kadir, poor litigant. So I don't see anything wrong with the use of the word policy in and of itself. Whatever that policy is one which is to solve a problem judicially, legally, within the confines of the law.
Yes, and there are two, I'm seeing question coming through, which is going to be asked here. Coming through from online.
Yes. Good afternoon, everyone. Good afternoon, panelists.
Yes.
The question is from Joel Taylor. I think my understanding of the idea of judicial policy is how a court sees its role in the society which it serves. Gleaning from the discussion, the CCJ seems to see its role as collaborative with the legislature. It also considers the progressive development of the law with the Caribbean space. The idea of separation of powers is sacrosanct to the people, the Caribbean, and Caribbean constitutionalism. Do you think the CCJ's ideals challenge this very fundamental principle of the rule of law?
Well, I suppose there are two questions there, quickly before I respond. One is, has the CCJ demonstrated in its conduct that it is collaborative with the legislature? That's the first question. And secondly, whether by reference to their judgments, we see anything saying that they are undermining the separate three arms of government that we have in our democracy. Those are the two critical questions as I hear them. Any thoughts on that, Mike or Larry or Filippo, Aliano or Bobby? Quickly.
I mean, I would say no to. I'd say no to both. It is a liberal court.
Yes.
It is certainly it's not a conservative court.
Yes.
And as I've said here before and elsewhere, so has the Privy Council been at points in time. Right. It's not a Privy Council CCJ court. You have a bench that is a much more liberal, progressive. I don't know if it crosses the line to activists, but court. And that may change as people change. So I don't see that as defining the court.
But there's no collaboration as I've seen it.
I've not seen it, no.
Okay. Any other question that, yes, Denise?
Thank you. I wanted to speak to this issue of judicial policy or collaborativeness.
Yes.
As far as I'm concerned, and in fact Lord Reid said it, the duty of the judge is to first treat with the plain and ordinary meaning of the matter that they're interpreting. Mm-hmm. So if it's statute, they look at it and they say, what does it say? Mm-hmm. And unfortunately, we have in the past seen judgments of the Privy Council where they have taken a different view. Certainly I have. In Jamaica seen where they take a different view on a capital punishment issue from their decisions in other jurisdictions, their own, and maybe other Caribbean jurisdictions. So we have seen imprecise decisions coming out of the CCJ where you can't really say for certain what they believed then. It may well be that now they have decided to take a more definitive approach in their interpretation and application of the law.
Did you mean CCJ? I think
I'm so sorry. Did I say CCJ? I meant the Privy Council.
Yes,
I'm
yes,
so
yes.
sorry. I meant the Privy Council. I have seen decisions of the Privy Council which were imprecise. One could not follow the reasoning in relation to capital matters. And one hopes that perhaps they are no longer there. But for my part, I think that we have seen the CCJ applying the law as it stands, whether legislative or common law, and I frankly can't understand why we would not go to a court that is so much more accessible. Why would we find that in their original jurisdiction they are trustworthy, but not in their appellate jurisdiction? It's the same judges. Why wouldn't we have them come to Jamaica and hear our matters as an apex court as they would do in the original jurisdiction? And so, for my part, accessibility, reliability, consistency of approach by the judges make it worthy of adoption in Jamaica.
We thank you for your comment. I don't think it was much of a question. One question from you, Shirley. and Maurice behind as well.
Thanks, Mr. Moderator. Good afternoon to all. I just want to express my view. I really think it's inappropriate for a court to be the executing agency for any type of funds, irrespective of the source of the funds. It just doesn't go down well for a court to be in charge of distributing funds or executing funds. Let me just use that word. But to make it worse, one of the donor groups to the CCJ is UN Women, which is an outspoken international LGBT advocacy group. And so I just want to make that clear. Secondly, one of the concerns I have about the CCJ is that it would appear that they are willing to impose their own philosophy in order to achieve certain results, which to me it seems can be contrasted with what appears to be the approach of the JCPC, which certainly which came across, or which comes across in the J. Chandler case. As an example, I want to read a quote from Mr. Justice Peter Jamadar. He gave an address to the Belize Annual Law Conference in 2022. And this is a quote. I'm quoting. In effect, the decision in Nervais and Severin is monumental in Caribbean jurisprudence because it establishes that even the literal text of a constitution is not infallible and is at once subject to certain basic underlying principles. What becomes normative and authoritative is ultimately not the letter of the text, but the basic deep structure, certain non-derogable features, principles, and values that underpins, informs, and constitutes the text as a constitution. End of quote. So then it would appear to me, and this is a viewpoint, it seems, which other judges on the CCJ, I'm sure, it would certainly appear to me that the CCJ does not consider itself to be bound by the text of a constitution, particularly, it seems, in what it considers to be human rights values. And that, to me, is a very, very serious concern, that the CCJ does not appear to consider itself bound to the text of a constitution. Comments of the panel, please.
Well, there are two things. I'm not sure there was a question, there's a statement, but I'll say this much. And as we go down that road of textual and literalist and so on, we know it's the same commentary being made about the U.S. Supreme Court as to whether Scalia is textual or literalist and whether or not this other judge is liberal or the rest of it and so on. So it's a commentary that is generally made of courts, and courts will change from time to time. The real point, I think, in my view, that you're getting at is whether we need to do greater analysis on an ongoing and open basis by looking at the judgments of the CCJ, as we would for the PC, to determine whether or not we're satisfied that they're serving that third arm of government function, which they must, in the public's best interest. And it's a conversation we will have to consider. And it is part of what my own view is, that we have to, on an ongoing basis, have commentary on cases in an open and frank way, where we can then see what is happening and determine the extent to which we are being served. Or if, and we're not saying that is happening, the courts are going off the rails. So I understand that. But
can I get 1 minute?
Yes.
The court is not bound by the text. The Privy Council wasn't bound by the text of the Constitution nearly 50 years ago when they found separation of powers in hands. That's not in the text.
Thank you. Thank you. Actually, I was just going to say that our friend there I was going to say, like, if you can go to the text of the Jamaica Constitution and find anything that addresses the issue of the separation of powers, I would be happy. But the Privy Council read it into the Constitution and we were fine with it. 50 years, hold a second, wait a minute, ma'am. We were fine with it because the Privy Council did it. I have a fundamental problem with us when our judges are doing the same thing. When they did with Donahue and Stevenson, as I said, and Hellyburn and Heller, we didn't have any issues with this thing. They taught us the High Trees case, Lord Denning. All of these are things they did. There was judge-made law. We didn't have a problem. But all of a sudden now, we are saying that these judges of the CCJ, sorry, I'm getting a little excited. The judges of the CCJ somehow are doing something extraordinary. And given because of rights with, you said LGBT rights and so on. My feeling is, mind you, I do not personally subscribe to some of those things, but they are human beings too. And they're also entitled to the same rights that you are entitled to and that I am entitled to. And who gives me the right to determine that they should have not rights simply because I have a different belief? I can have my belief and still say you should have your rights. There's nothing wrong with that. And it doesn't mean that because I say you should have yours that somehow I am coddling with you. No, I still disagree with you, but I could be mature enough to say you are entitled to your rights even though I disagree with you. And that is the level of maturity to which, in my respectful view, we need to ascribe to, or certainly seek to get to as a Caribbean peoples. Because they are our brothers and sisters. And perhaps we should address the issues that we have with them, not within the law, but perhaps in social settings or something of the sort. So, is the CCJ perfect? No. Because judges there and they're human beings. The case I spoke about that I did, for example, I asked for damages in my case. The court said, no, it would be an affront to the public conscience to give damages to this man when he's awaiting a murder trial. I happen to disagree with that vehemently because my position is if his rights are breached now, make a determination as to whether he should get his damages today or not. Don't leave it for trial. But so what? I still support them because as I used to say to my parents when I was a child growing up, do not mistake obedience for agreement. I know I have to follow the rules. I get it, because I live here at you, but I can think for myself. So I don't have to agree, I just have to obey.
Let me ask Ms. Maurice quickly. Maurice, there's a question from Maurice Saunders. Or comment, as the case may be, I'm not sure. Yes.
No, something new or different. And if I may put it in two parts. First one, Apex Court, which, as I understand it, will give consideration to other matters outside of the exact facts of a particular case. Extraneous matters will give consideration to those things. Now, in relation to Jamaica, every few years, a pollster or pollsters ask the public the question, would you support the decriminalization of buggery? Every few years, 80% of those in the poll, which I think most people accept as being 80% of the people of Jamaica, say no, do not decriminalize. Question to the panel. Would the CCJ take that into account were a case from Jamaica arrive before them for a decision? Related to it also, second question. I hear expressions of rights, human rights, expanding rights. And it has often occurred to me that sometimes we're speaking of different things. I remember once being in conversation with a lawyer, a graduate of Oxford University, and we were discussing this concept of rights and the origins and sources of rights. And I explained my understanding of what the origin and sources of human rights were. And so I asked the person, what is yours? The person said, she differed. So I said, well, for you, where do human rights come from? She said, well, I suppose from other persons. What do you think? Thank you.
Bobby, you have a comment on that? No? Philippa?
Can I answer the first one? Just quickly? Maurice, I hope not. To your first question, would they take into account the fact that polls show 80% think so and so? I hope not. What they should take into account is the fact that there's a savings clause put in our Constitution in 2011 that protects that law. That's what they should take into account, which our court recently upheld. And I think they would. So.
If you ask Mike.
Okay, I just want to put the context. So we come across the judicial policy construction, which is an activist approach to the law. And then we have the concept of apex court. These are terms, I'm not a lawyer, but these are new terms. And then we have a judge saying that the actual letter of the law is not really relevant. How do all of those considerations fit into the CCJ being a liberal court?
Well, first of all, I hope no judge has said the letter of the law is not relevant.
Well, I don't know.
It's not.
Is that what he said, Jamada?
No,
it's not
binding. It's not definitive. It doesn't
well, it's not
determine
relevant.
the matter.
If it's not binding, it's not relevant. It may or may not be, depending on the circumstance.
But you asked me what I meant, so let me answer you. There is a spectrum of conservative, liberal, activist, various words that one can use to define the approach that a judge takes to matters before him or her. Activist is a word that I would use at one extreme. Conservative and liberal are words that are closer to the center, and the liberal judge is the one who is more willing to look at the circumstances of today, whether things have changed, what is the context in which words are used, and so on, as opposed to just being a literal constructionist. And this is not just a constitutional point. It's an interpretation of contracts. It's in your general scope of carrying out your function. Do you take a purposive, interpretive approach, or do you take a literal approach? And the present CCJ bench appears to be less of a literal court and more of a purposive. Liberal is the word I use.
So may I say then that someone like myself, a citizen, should understand that the CCJ, the judges may or may not pay attention to the Constitution as written, depending on, I'm not quite sure what. Secondly, the judges are seeking to be an apex court, whatever that is. And thirdly, the judges are seeking to come into collaboration with the legislature to make some sort of judicial policy. Is that how I should understand the CCJ?
Let me answer one point quickly. Apex is the general meaning of apex, final, nothing beyond it. So that's the easy bit. As to whether or not the CCJ is acting without regard for the Constitution, I think I heard Mike say it, I suppose Lara would echo it, and I think all of us here would echo it, to say that they cannot act without regard for it, including because when matters are presented before them, the very Constitution is put to them for them to decide upon it. But let me answer in this way, though, and it's probably a problem that many people do not bear in mind. That while we speak of the Constitution as our grown norm, our most important source of law and the rest of it, The very Constitution that we speak to gives the court the right to interpret and apply everything, including the Constitution itself. So if it has the right to interpret everything, including the Constitution itself, it must consider the Constitution in context and by reference to the matters that come before it. And for that reason, though courts do not want to admit it, and I suspect they should not, the point is that I like to say that the most important source of law is not actually the Constitution. It is the courts. Because who has the final authority to interpret and apply? It is he who has the final authority to determine meaning. And the meaning is what follows you. If you listen to the minister earlier, she said, when the courts interpret and apply, if we do not like, we will pass other laws to change that meaning. But there was an implicit acknowledgement by the minister that it is the meaning of the courts, which they have constitutional authority to have, which will ultimately determine what binds us. So that was clearly said by the minister herself, albeit not as directly as I just did. And that is in fact the correct approach in all of our common law systems, wherever you find them. That's why, for example, you saw the big news the other day, the Roe v. Wade situation in the US. It was the courts that determined whether or not you could abort and in what particular way, and there's another court which, however many decades after, determined another way. If the thing were so set that the Constitution or whatever the law was what settled it without the word of the court, why then would people be going to the US Supreme Court or any other Supreme Court on matters for them to give definitive meaning? Because they have the right to do it. So right now, I think we're going to take one final question and then call it a wrap. Yes.
Hi, Dr. Malcolm. Thank you. Miss Candice A.E. Walker on the YouTube, she said, I don't agree that a clinical approach to the law is ever adopted when matters are being appealed. I would like to know, where do we find that balance?
Well, that balance, I don't know, what would your comment be, Philippa? She doesn't think there's a clinical approach that is ever adopted.
She said, I don't agree that a clinical approach to the law is ever adopted when matters are being appealed. I would like to know, where do we find that balance?
Of how the courts behave.
This is between the CCJ and
No,
the
not
PC,
between
or
CCJ,
just
in a
general?
very general way. Generic. It's a generic question.
Balance between what, though? Between the law or the judge's own view or personal opinion?
I take it as their personal opinion. What is the ambit, what is the extent to which they may adopt, other than a very clinical, literal approach?
Yeah, even a clinical, literal approach.
Or to become more purposive rather than literal in their approach.
So the challenge would, I think that this is a discussion we've had, the challenge, if the judge is going to apply their own personal perspective on a socio-economic issue or religion or otherwise, as opposed to the law that's before them and the legal precedent that has been set, including common law. And so I don't know if I'm going to properly or fully answer her question, but a clinical approach would be required to examine the law.
Mike, any final thoughts on that?
You're saying that, yes, a clinical approach, but she's saying, I don't agree with that approach. I guess she doesn't agree with the strict approach, and I think she's looking for something that's a little bit more
I think that
flexible, a little bit more, maybe a personal, something just...
I think as we wrap it, in the interest of time, I think that the short that we've heard, including from Lord Reed, including from the panelists in their own way, to just encompass it, is that a court can never simply look at the law and do what I call counting words instead of reading. You cannot simply say, well, the word said the horse is red, and that is all you say. You have to look at the context in which the matter arises and look at a number of other factors to determine what is appropriate in relation to each case. So to that extent, A clinical approach is never adopted and should never even ever be adopted. Because if you were to do that, you would then constrain the very function that has been ascribed to the courts. So I think we can wrap by saying that we agree with her that a clinical approach can never be adopted, and it is the appropriate approach to take. So again, we want to thank you all, including the participants who took questions to us and others who have made comments online that we're not reading either, for having participated in what is an extended discussion well beyond what we had hoped for. But again, we find it to be useful, and we want to continue this dialogue beyond here into other spheres and into other programs and initiatives that the law of the class of 97 commit to being involved in, as does the Faculty of Law here, in greater interest to the public. And as I close out, I want to say, of course, that we thank, firstly, I want to thank, and start where persons normally end, I want to thank the participants for being involved. But, of course, these programs come together with a lot of participation of persons. So we want to thank, of course, the Faculty of Law and the class of 97 for having, again, collaborated. And we're talking about collaboration now. In putting a program of this nature together, we have had the benefit, and I must personally say, while I was in many ways involved in the program coming together and so on, but we have had tremendous support from our administrative staff led by Mrs. Arlene Supersad, who all the panelists here and everybody will know just how much she reached out. And every single day, literally. And of course, Odisha and all the other persons from the Faculty of Law who were involved. Our technical persons, we see Ishmael, who was at the back there for having put all of this together, and his team, the UAPR and persons beyond that, and all the entities, the principal, the faculty, through the dean and everybody else for having done this. And of course, for the class of 97 who are here represented and who continue to provide support, including Larry flying all the way from Barbados here to be involved in this program, to show the commitment of this class. So we thank you for all of that. For those I have missed, consider yourself very well thanked for your participation and for the ongoing support that you continue to offer to the programs and initiatives, not just of the faculty, but for the class and all the law and all the other things that we're doing, all in the interest of the public. It's about, as I say, taking things from the cathedral to the streets, and we're hoping that we can, in a single way, one step at a time, get better to doing that. And of course, I want to end by thanking the persons who ensure that all of the magic that has happened comes to the public, and that is our press. We are very well represented here by the press and beyond here as well. And we want to thank the press for the hard work you do and for your commitment to sitting here for the extended period you have sat here to take the stories. And I know you have even committed to having a few words to some of us, our panelists, for purposes. So I've already done what I've done. I've falsely imprisoned everybody up here. So, for your value. So thanks again, and have a wonderful rest of the evening as we await further word from the press. Have a good evening.